Hello everyone, and welcome back to the channel. I'm Nova Rain. Today we're discussing the latest developments in the case against former Letcher County Sheriff Sean Mickey Stines, who is accused of shooting and killing District Judge Kevin Mullins inside the Letcher County Courthouse in September of 2024. And I've got some video clips from our friends at Court TV. I wanted to live stream it and discuss it with you all, but had a little problem with my OBS. I had to get my son to help me out with that, and so I'm hoping, if I ever do get monetized, that, I'll be able to maybe invest in something like StreamYard or something. But right now, this seems to be, working pretty good for me, as long as I don't run into those issues. I was actually, I had the video, on screen. It would show that, but it wasn't catching the audio. So I had to get him to show me a few things about this. He's pretty smart about the OBS. He actually has a channel also, and his is about horror movies. He really enjoys those. So if you're interested in his channel, just hit me up in the chat, and I'll try to get a link for his channel for you. So I'm going to try to play some of it, and then we'll try to discuss a little bit of it. And I'm going to try to be objective, not have any kind of personal feelings in it. I do live in Letcher County, and this is something that happened in my small town, and most of us knew both, Kevin and Mickey. And for me, I always got along with both of them. They were, Mickey was good to me. Kevin was, good to me. So, okay. Well, anyway, I'm going to go ahead and play a little bit of this video. See, the dark-haired lady in the white shirt, that is Kevin's wife that they're showing there. And I do have, sometimes the commercials pop up, so I'll try to skip them as soon as possible, or I'll try to jump over to another screen. I'm not real experienced with this, so I'll try to do my best. Let me well, I guess I need to show you guys the screen. That might help, so y'all could see. Here you go. Let me go back and show you. Let's see. This is the lady I was speaking about, the dark-haired lady in the white shirt. That's Kevin's wife. Let's see if we can skip on to. Oops, a little bit too far. Okay, right here we'll see the judge. This is in Leslie County Courthouse. There's Mr. and Mrs. Bartley. There's another defense attorney. And the judge should be coming in here in just a few moments. He's skip it on just a little bit. Okay, here comes Nikki in.
Bartley, if you'll identify yourself and who's the council table with you.
For sure, but I have just 1 second on the local box, sir.
And again, this is from our friends at Court TV.
For sure. Jerry Bartley on behalf of Mr. Stines, also co-counsel Ms. Kerry Bartley, as well as co-counsel Mr. Jim Cox. Your Honor, there's members of my staff, but they're intended to sit in the gallery and not otherwise at the table.
That'll be fine. All right.
Can we be seated, Your Honor?
Please.
Thank you.
All right. Since we last met, we've got some motions that are still outstanding. We want to try to address some of these and start looking at heading towards hopefully getting this matter set for trial. First, there's a pending motion for a hearing pursuant to KRS 532.135 to exclude the death penalty at trial. The Commonwealth has filed no notice of aggravated circumstances up to this point. My understanding, after briefly speaking to the parties and chambers, is that we're going to hold that motion in advance, pending the resolution of any other potential evaluations, and then if the Commonwealth files notice, readdress that. Is that correct, Mr. Bartley?
That's correct, Your Honor, with the caveat we discussed that obviously will be in ample time so that it wouldn't affect trial strategy.
Absolutely.
Or if there's any additional experts as a result, such as mitigation, Your Honor.
Absolutely. And that'll be.
Okay, I'll stop it right here just for a second. So they're talking about whether or not they're going to, I think, exclude the death penalty in the case. And from my understanding, that they're going to wait till a little bit later to to decide that. So, if y'all understood it different, just let me know. But I'm thinking that's what they were saying. Okay, we'll go on with it a little bit more.
Set pursuant to the rules. Next, the Commonwealth's given notice regarding a criminal responsibility examination. Mr. Steele, do you want to address that?
Your Honor, Ms. Raines will address that issue.
Your Honor, the Commonwealth, as the court noted, has filed a notice requesting a second mental health evaluation to be conducted by a private expert retained by the Commonwealth, Your Honor. It's our position that the Commonwealth is entitled to that. The defendant has filed notice pursuant to Rules of Criminal Procedure 8.07, subsections 1B and 2B, and accordingly the Commonwealth is entitled to rebut any defense related to insanity or any evidence going to issues of guilt or punishment related to mental disease or defect. So it's the Commonwealth's position that we are entitled to a second evaluation. We're not requesting funds from the court, Your Honor, for that to be done by our private expert and for Mr. Stines to submit to that evaluation, Your Honor.
Yeah. And I've read the pleadings regards to that. Mr. Bartley?
Just trying, the criminal rules, I think, are pretty clear that in fact we have to give notice in terms of our intention to introduce the defense of insanity. I hate that nomenclature, but it still persists, so I will use that for purposes of today's hearing. However, we've given that notice. We gave that almost as soon as we got into the case. And we identified Dr. Drogan as our intended expert. At this point, he's not completed. We'll comply with the rules in terms of doing so. But the rules of criminal procedure that were cited in the notice, I believe, are 807. And under that rule, Your Honor, I agree that they are entitled to have Mr. Stines evaluated. And that's why they filed the first notice and they asked for the court to send the KCPC. They could have gotten any expert they want.
Okay, so he is saying that they could have got any expert they want, and they did, to my knowledge, and now they're wanting another expert to evaluate Mr. Stines. He looks a lot different from whenever he first, this first happened. Looks like, this is taking a toll on him. Physically and, I'm sure mentally. We'll go on.
Again, I mean, like they said, they've got the money. They can send them wherever they want to go. KCPC is the Commonwealth's, as they've always made very clear, that is their facility. And they availed themselves of that facility. And he waived his Fifth Amendment right as to an examination. It's a quid pro quo. If you put mental health at issue, then I believe that the Commonwealth has a right to have him examined. And he's done it. And I look in reference, Your Honor, to KRS 504, the section cited in the civil rule as well as
Yeah, he's done that already. Now they want another.
in RCR, it's 807, Your Honor, it says that they're entitled to an evaluation. And I believe under the rules of statutory interpretation, the first thing you look at is plain language. To me, "and" signifies, and 504 is adopted by reference into the criminal rule that's cited for the notice, Your Honor. And I believe that "and" in its ordinary meaning means singular. And I think the concern is multiple. First of all, if you look at the case that I cited there, it is Benjamin v. Commonwealth, 266 Southwest 3rd, 775. And in that case, they were looking at a defense request for another evaluation, and they said basically, if you don't like the result, that's tough. And it's an even playing field I would urge the court to hold here now. Again, if you file notice of insanity, I think there's a limited waiver of your Fifth Amendment rights, but the cases make it very clear it's limited. It's limited in scope, and the statutes address what should and should not be brought in. But the remedy, if he were not to have complied with the first examination, would have been that the court could do anything up into striking his entire defense.
Yeah, so from what I gathered from that is maybe that the Commonwealth didn't like the results of their first expert, so that they're wanting another expert to evaluate Mr. Stines. Okay, we'll go on.
But in this instance, Your Honor, we willingly, readily presented him to their expert. That was their expert that they asked him to see. And now what they're asking the court to do is make him go to another. Now, what I suggested in my response was that they could very well, do I believe they can hire another expert and pay them to come in and testify? Yes. I don't think there's anything I can do to stop that. It's the evaluation that I think is the invasive part, Your Honor, that would subject him to yet another waiver of his Fifth Amendment. We are now 2 years out. You know, the first evaluation will be much more relevant. But if they want to get there and get another opinion and have somebody come in and say, Drogan and Dr. Allen, there's reasons not to believe that testimony, I can't refer to it, Judge, but that testimony that the court's aware of, then I think they can. And they can get there by simply having them review the procedures by KCPC. They have all the data. They have all the data that is there. And they can provide that to an expert. He can look at that and he can opine that the previous opinion is incorrect or impeach it, Judge. I'm trying very hard not to breach the reference, Your Honor. I don't know.
maybe it's just me, but you know, we've seen that close up of him there, and I don't know, he looks like a broken man. And I don't know, you know, it's just being in jail for 2 years, or well, I'm sure that has something to do with it, you know. It just looks broken. We'll go ahead and go on.
But I think that that's it. In the civil context, there has to be, you're looking at, is there something flawed in this examination? I mean, I think if their motion said, when we send KCPC, they rushed and did it, and it was incomplete, it was this and that, they've had the evaluation, and we agreed that they could share that with whoever they potentially want to look at it. Then I would say today, if there was some evidence they could put on to the court that this was flawed, of course we would cross that and ask to subject it to proof. But I believe that's what they should have to do, rather than just have him again waive his Fifth Amendment right, go to a state expert again. He was compelled to do it from the jail twice. He was compelled to do it at KCPC, Your Honor. And I think that, you know, my question also becomes is, where does that stop? I mean, at some point, how many examinations do we send him to? If this expert, whoever it may be, were to agree with both our expert and Dr. Allen from KCPC, do we get another one? And I think that's exactly why the courts have said that the waiver of the Fifth Amendment in this context should be limited, Your Honor. And I would ask the court to find that he did his part, and he understood the quid pro quo. We discussed that on the front end, but what we didn't discuss was a quid pro double quo, Your Honor. And so I'm asking the court they can still get their expert to rebut. I understand there are cases that talk about they get an opportunity to rebut it, but there's nothing that should compel him to once again waive the Fifth Amendment right and go see an expert that the government mandates, Your Honor. They can get to the same point without compromising that yet again, Your Honor.
All right, Ms. Dawn,
Yes, Your Honor. The Commonwealth's position is that it's clear here, there is no statute, rule of criminal procedure, or case law that would serve as precedence for this court saying that the Commonwealth is limited to a single evaluation of the defendant as to criminal responsibility. There is nothing out there that says that. And
so the defense is not wanting him to be subjected to more evaluations in the Commonwealth. They do want more evaluations. I'm assuming they're not satisfied with the first one. And, you know, that's my opinion. I'm assuming they're not satisfied with the first one. I mean, everyone can draw their own conclusion on that. And let's say that they keep on going on arguing about it. Let's see. We'll go ahead and play a little bit more for you. And again, this is from our friends at Court TV.
The Commonwealth has the burden of rebutting the offenses that the defendant has indicated he intends to present. The Commonwealth's
It's like it lost signal there for a moment.
position is that the reliance on the Benjamin versus Commonwealth case is completely misplaced. That was a very different situation. In Benjamin, there was a defendant who was asserting both competency issues as well as criminal responsibility. In that case, an evaluation had already been conducted. The defendant had not, until the day that trial began, articulated specific reasons for a request for funds for an additional evaluation. At that time, the court said, no, your request isn't timely, it's not necessary, and then an appellate court in reviewing that said, due process was not violated, Your Honor. This is markedly different. We're not here asking the court for funds. We're certainly not requesting a second evaluation the day the trial begins. We don't even have a trial date at this point, Your Honor. So the Commonwealth feels that our request is valid and that a second evaluation should be conducted of the defendant. Additionally, the experts at KCPC, I believe the defense has referred to as the state's expert. Well, Your Honor, The Commonwealth is not conceding that defense can call an expert from KCPC who evaluated the defendant at trial as their expert, but if they intend to do so, then certainly that expert would not serve as the Commonwealth's expert, and therefore we would be entitled to obtain a private expert to evaluate the defendant in this case. As far
Okay, I see what they're saying, because I believe that they think the defense may call KCPC's expert as their expert at trial, so they're wanting another expert. Okay, I see what they're saying there, because maybe they think that the defense will call KCPC's expert, or I don't know if any kind of motion orders, or maybe it's on some kind of discovery that they're going to. I don't know exactly how that goes, but I'm sorry I have to keep stopping that. But I wanted to be able to show you this, and Court TV, you know, this is their video, and so you know, I need to, you know, put commentation, you know, be able to make comments, and not, you know, for it not to be a straight video of what they have.
As far as any waiver of Fifth Amendment concerns, that is explicitly addressed in the Rules of Criminal Procedure, specifically under 8.06 and 8.07. It says that any statements made by the defendant in the course of these examinations cannot be used against the defendant unless they choose to use those examinations and evaluations to their benefit. So that is addressed directly in the statute. That argument is completely without merit. So we would ask that the Commonwealth be allowed to have their private expert conduct an evaluation of the defendant.
All right. Ms. Martin, response?
Yes, sir. That's completely the inverse. I agree. There's nothing out there that says they can't, but there's nothing out there that says they can't. And so my point is this, Judge. I mean, so it should be limited to the intention of the rule. The intention of the rule was to give a fair play. He waived that right. It should be limited, Your Honor, in terms of whether the statements are privileged. That blanket prohibition of the statute is riddled with exceptions, and I'll be very surprised. I'll be extremely shocked if we get to a trial and there are not statements from any of the examinations that come in. It's riddled with exclusions, Your Honor. I ask the court not compel Mr. Stines to, you know, once again, Judge, produce evidence that is potentially used against him, Your Honor. Again, you can accomplish both goals by letting them have the prior evaluation, the raw data from that examination, and they can still have someone to rebut them. As far as whose witness it is, they asked that the court order he see their expert. That was the first notice, and they said their expert was going to be a KCPC. Now they're asking for an independent expert. They were both calling expert. The fact that I may call them is irrelevant. I mean, they weren't the courts. I didn't ask for it. So obviously it's their witness, Your Honor. So regardless of who calls them or whatever that may be, we didn't ask to see Dr. Allen, but we do want to hear what he has to say at trial, Your Honor.
All right. Ms. Dawn, if the court does order another evaluation pursuant to the Commonwealth's request, what kind of timeline are we looking at?
Your Honor, we don't.
Yeah, the timeline, you know, let's see, the trial has been, you know, delayed 2 years so far, so hopefully, you know, if this is ordered, that it will be done quickly.
Foresee our expert he's located out of state in Indiana, but fairly nearby.
Okay.
Of course, there would be travel time and we would accommodate his schedule, but we're not expecting any significant delay, Your Honor.
Okay.
Your Honor, if I may,
Sure.
in terms of if the court does permit the second
Sure.
expert, Your Honor, then what we're asking is that, once again, Dr. Drogan be permitted our
Absolutely.
original expert. But, Your Honor, I think it's very prudent, and it's not without precedent, actually, with Dr. Allen, that the KCPC doctor be there as well, because if they're going to rebut and be critical of what he did, Your Honor, then I think it is only fair that we should be able to have him observe so that he can respond to the criticisms that they place on the KCPC examiner.
Okay, so the defense is wanting, if the court does allow a new mental evaluation, the defense is wanting the KCPC expert to be there also. So we'll listen and see what the judge decides, or if he decides today.
All right.
Your Honor, if I may, if the Commonwealth does not have any objection to Dr. Grogan appearing, we would have an objection to Dr. Allen.
If I do order it, I would have obviously no issue with Dr. Grogan being present. I am going to have to look at whether or not Dr. Allen being present will be appropriate in regards to it. I'm not making a ruling yet in regards to another evaluation, but I do think the court inherently, under RCRA 7 1B, has the authority to order the second evaluation, but I want to review the pleadings and I will get an order out to the parties shortly in regards to that, because I do want, timing-wise, if this is going to be done, to get that moving. So, next issue before the court.
Okay, before he starts the next issue. Okay. So, what we've had so far was about the death penalty, and no decision's been made on that so far, whether it's going to be allowed or not. And then we've had about the second mental health evaluation. So let's see. Let's go on to the next order. Well, the next motion. Let's see, get you back on here. Okay.
Your Honor, can I have one more thing, Your Honor? It
Sure.
shows that if the court does in fact order that examination, then I believe that we're entitled to discovery as to fees paid, and as well as
Sure.
hours as well. I just want to make sure we get that discovery as well.
That'd be no problem at all.
Thank you.
All right. Next, let's go ahead and, Mr. Bartley, you've got pending bond motion.
Your Honor, I'd ask that Ms. Bartley take that issue with court.
Ms. Bartley, go ahead.
Yes, Your Honor. Carrie Bartley on behalf of Mr. Stines. Judge, the court has issued an order basically granting us the evidentiary hearing that we requested. It's the Commonwealth's burden to put on proof that the defendant's guilt is proof is evident, or the presumption is great of his guilt of a capital offense. We don't believe that they would be able to do that. Cases under Markham v. Broughton say that essentially where conflicting evidence creates a plausible basis for self-protection, which is not necessarily what we have here, or a reduction out of the capital range, that the Commonwealth can't meet that burden. And so, Judge, what we would ask is just for the court to hear the Commonwealth's proof, and then if necessary, then we have some brief proof that we would like to put on as well.
All right.
Judge, we discussed this previously in common with this record receipt. We're going to submit to the court the recording of the shooting that day.
Okay.
It was played, it was introduced.
It's part of the record.
It's part of the record, but we're going to submit it to you for your
Go
consideration.
ahead.
And Your Honor, we would object to that. I believe it's, the Commonwealth has to put that on. The rules of evidence apply. The court has rules of evidence apply. We don't think the Commonwealth can lay a foundation for that video today. I don't think they have a witness to testify to that today. And so I don't think that it's appropriate for the court to take it into consideration today if they can't put on any evidence as to.
Okay, so the Commonwealth is wanting to introduce the video of the shooting into evidence, and the defense is arguing that they had to put it, if I understood right, they have to put it on the rules of evidence. So let's see what happens here. And I'm trying to be, just I'm trying my best, not to lean either way on this, I'm the type of person, I like to hear the evidence and see the evidence, and, then you go from there and make your decision on things.
All right, that objection's overruled. All right,
You overruled the
If
objection,
I
so
may
that
just
was
say, on
submitted.
that issue, and I'll be very brief, this was introduced in the preliminary hearing, foundation was laid, same council was present during that, and no objection to it being made.
And Your Honor, at that point, if I may, the rules of evidence do not apply in the preliminary hearing. The rules of evidence do apply today under the Young case, Judge. The court cited that in its own order. And so I would, again, vehemently object to the record to this being introduced without any foundation being laid at this particular hearing where the rules of evidence do apply. And, Judge, I just don't think it's appropriate. I think that, it sort of flies in the face of applying the rules of evidence, or for that being the court's ruling, that those rules apply, Judge, if we allow the Commonwealth to put in proof without having any testimony to that effect and without any witness being here to be subject to cross-examination as to that issue.
Okay, so she is arguing that the rules of evidence does apply today.
well, just
Judge, under Rule 1101, applicability of rules, it says, subsection D, rules and applicable rules other than with respect to privileges do not apply in the following instances. Number 5, miscellaneous proceedings, without reading all those, it says, and proceedings with respect to release on bail or otherwise.
Yes, Your Honor, and again, I can reference to the court's bond order where the court specifically references to the Young case, Judge, that says that the subject to the rules of evidence, Young v. Russell, upon request for bail, the defendant may testify, call witnesses, etc. So the rules of evidence absolutely apply. It's in the Young case. It's black letter law, Judge.
all right, the court's going to overrule the objection. The facts surrounding September 19th, 2024, which is the basis of this action, there is information in the record previously which transfers from the district court case pursuant to the indictment. I do believe that it would be appropriate for the court's consideration. So,
Okay, so it sounds like he says because there was information in the record, and I'm assuming it's from maybe some previous hearings and other things that may have been submitted. I don't know about that, but I know they showed it at a previous hearing, the video of the shooting. So he is absolutely allowing that to be admitted into the record.
anything else in regards to, anything else you want to do on bond?
Yes, Judge, I have a witness if I may call.
Absolutely.
Defense would call Ms. Sherry Stines.
The defense is calling Ms.
And
Sherry
Judge,
Stines.
it's okay, I'd like to stay at council table. I think that there's an issue with the podium that
That'd be fine.
kind of goes up and down.
Now, this is Mickey's aunt that they're calling that the defense is calling to the stand.
Ma'am, you would stay right at the podium. All right. If you will, raise your right hand and be sworn. Do you swear from the testimony you give me the truth, whole truth, nothing but the truth?
I do.
All right, ma'am, if you would state and spell your name for the record.
Sherry Stines. Sherristines.
All right. Ms. Bartley, may I ask?
Yes, Your Honor. Ms. Stines, again, Sherry, just tell us where you're from. Where do you live?
I'm from Neon, Kentucky.
Okay, is that in Letcher County?
Yes,
All right. Do you know Sean Mickey Stines?
yes.
What do you call him?
I call him Bubby.
Bubby? Okay.
Yes, he's biologically my nephew, but my mother and father raised him.
Well, that was my next question. What's your relationship to him? So,
Yes.
you're his aunt, is
Yes.
that correct?
Yes,
All right. Now, how close of a relationship do you have with Mickey now?
very close.
And has it always been close?
Yes,
Okay. How much older than Mickey are you?
I'm 62, he's getting ready to be 45.
Did you ever live with Mickey?
Yes.
And is it okay with you if I call him Mickey? I know you call him Bubby.
Yeah, I
but
call
don't
him
think we're that
Mickey,
close
yeah.
yet, so he may not like that. I want to ask you about the date September 18th of 2024. Do you recall?
Okay, so she's she's asking her about the day before the shooting.
All the events of that day?
Yes, it's the day he stayed all night with me.
Okay. And you said that's the day he stayed all night with you. So you saw Mickey that day, is that
Yes.
right?
Yes.
Okay. And about what time that day did you see Mickey?
It was late in the day when he came by the house. It wasn't dark, but it was later in the day.
Okay. And when he showed up to your house, did you know he was going to stay the night with you?
Yes, he told me.
Was it common for Mickey to spend the night with you?
No.
Why was he going to stay the night with you that night?
I think it was going to be just to let his wife and daughter rest, where he had been such a nervous wreck and wouldn't sleep.
Okay.
Yeah.
So you said he was going to let his wife and daughter rest. Now tell me,
Yeah.
why couldn't they rest?
Because he couldn't sleep and he was wiping the floors, and I guess he was aggravating them,
Okay. Now, did you talk to his wife or his daughter about that at all?
No, not that night. He was at the house, so I tried not to get in that.
When he came to your house, had he called you before and said, I'm coming over?
I can't remember if he called and said he was coming or not, but he knew he could come anytime he wanted. It's like his second home.
Okay, so.
Okay, let me stop that just a minute. That is kind of how it is around here, family don't always call, and let you know they're coming. They'll just stop by and come by. And for the ones who do not know what's going on with this case, let me give you a little bit of background real quick. Let me go back here to my screen. And we'll go on with this in just a moment. Here we go. Okay, so I'm going to give you some quick background on the case that we're listening to a hearing on today. And it's on September 19th, 2024. Judge Kevin Mullins was shot and killed inside his chambers in the Letcher County Courthouse in Whitesburg, Kentucky. Security video captured the shooting, and Stines surrendered to authorities shortly afterward. He has pled not guilty and remains charged with murder. And what's happening here right now, they had spoke briefly about the death penalty, and that's not been decided yet. And also, they spoke about the Commonwealth and the prosecutors. They want to have another private expert, and the defense objected, and saying that another valuation was not necessary, and the judge said he would review it and issue an order. So that's where we're at right now, and we have got up to they're discussing, and the defense has brought a witness to testify on the defense's behalf, on Mr. Stines' behalf. And what they're doing now, they're wanting to find out about bail. So we're going to go on with it a little bit, and we'll listen to Miss Sherry talk. And she's getting ready to talk about, she's getting ready to talk about the day before the shooting. Let me get you back to the screen. Get you back to the video screen. Okay.
So you said he came by later that evening.
Yeah.
And when he came by, did he bring anything with him?
He brought a bag, and in it he had those little tuna creations, And turned out it was like melatonin gummies and some over-the-counter Benadryl.
And did
Okay. And she is talking about September the 18th, the 2024. And so when he came by, that he had a bag, and he had some of the tuna creations, you know, I'm thinking it's those little packs of tuna. And then he had some melatonin gummies and some Benadryl, because he hadn't been sleeping.
do you have anything to say about why he had Benadryl or melatonin gummies?
Well, he hadn't been sleeping, and it's like he hadn't slept in 7 days and nights. And he had went to the doctor, and they had told him to take the Benadryl and the melatonin to help him rest.
When
I'm assuming it was that day or the day before. It was very close.
so he had gone pretty close in time to when he.
Yeah.
You don't know for sure the day.
Yeah. No.
Okay. And the doctor recommended to him to take melatonin and Benadryl to
Right.
try to get some sleep.
Over the counter.
Okay.
Okay, so the doctor had recommended for him to take the melatonin and the Benadryl. So, you know, I guess, you know, he went and got what the doctor had told him to get. So, I guess, you know, he was going to try to get some rest.
And when he got to your house, what did y'all do first?
And we just basically sit around, watch TV. I went in and I fixed us a little bit of supper. We ate. He didn't eat a lot.
What'd you make?
Pork chops, like green beans,
No,
potatoes.
I'm going to object this time. I don't understand the relevance as to what we're here for upon in regards to my question.
I'm gonna overrule the
He was objecting about, I'm assuming he's objecting about going into what dinner was. I wanted to hear that.
objection, but that's council.
Yes, Your Honor. So Mickey got to your house, you ate some dinner, and then what did you do? What happened?
Just sit around for a minute. He was real fidgety, walking from one door to the next. Just kept getting later, and I take oxygen at night. So I sat in my recliner at night and take my oxygen. So I give him a bed in my house. I have an extra bedroom. Told him to go lay down. He goes in, he lays down for a few minutes, and then before I know it, he's right back in the living room with me, and he's carrying a pillow. And I said, "Baby, can't you sleep?" And, no, I just can't. And he would take like melatonin and Benadryl, sit there, keep his phone in his hand. And he was watching his security cameras, watching around his house.
So he's watching the security cameras at his house?
Around his house, yeah.
At his house, okay.
Yeah.
And you said, let me go back to the melatonin and Benadryl. So he's taking melatonin and Benadryl. Did he take that at the same time?
Yes.
Do you know what kind of Benadryl or melatonin it was? How many milligrams, anything like that?
I don't know, but I've still got them at home in the bag he had them in.
Okay. So about how many, if you had to guess, or if you know, don't guess, if you know, how many melatonin, how many Benadryl did Mickey take that night?
I'd say about 3 to 4 Benadryl and about the same with the melatonin gummies.
And did that,
3 or 4 Benadryl and about the same with the melatonin gummies. It seems like that would put somebody out. I've had a problem, you know, before I was sleeping, and I used to take melatonin at night, and I didn't take a very high dose of it, but usually if I took it and I laid down, it took me a little while to go to sleep, but I didn't take, you know, the full dose that normal adults take, because, you know, I still had to get up early, so, yeah, 3 to 4 melatonin, 3 to 4 Benadryl, that would have put me out. I don't know if I would have woke up early, but, you know, I'm trying to be biased on all of this, you know. Like I said, you know, I knew both of them. You know, they were public officials. I knew both of them. And yes, I heard the stories, you know, about the judge. I don't know if they were true. There's been videos come out, women saying that it was true. I'm just going to keep all my comments, about things to myself. Because, I do have to still live in this town, and I love this little town, and I love the people here in this little town. Just good country people, and it's a nice place to live. I'm sure we have, we have our problems, but this was something we never imagined to happen. Never, So, I guess, I know I keep talking, but kind of got to because of we're using some of the video of Court TV. This is their video, and I'm so glad that they went in there and had this hearing stream for us. And I'm sure the trial will be also. So let's go on. Let's listen to Miss Sherry some more.
Doesn't seem to have any effect on him at all.
No.
And so, did he sleep?
No.
You said he was on his phone looking at the security cameras, and he was looking at the area around his house.
Yes.
Did he have concerns about what was going on around his house?
Oh yeah, he was paranoid. He thought somebody was going to be around his house and, I guess do something, bother something.
What was he concerned about in terms of someone being at his house?
He was worried about Lila and Caroline, his wife and daughter.
He's worried about his wife and daughter.
Yeah.
Did you say anything at all? Did you get any indication of why he would be worried about his wife and daughter?
No, but I knew he was under a lot of pressure, a lot of stress.
Did he mention that there had been any specific threats to him?
Nothing specific, but I just, you could tell the way he acted, it was bad. He was horrified. He was scared to death.
He was scared to death?
Yeah.
You don't know what he was scared to death of?
No, but, I had my theories, but...
Well, let's not talk about theories.
That's my theories, but that's not what it was, that I know.
Okay, so
She said she had her theories, but that wasn't what it was, and so she didn't speak of what her theories was. But okay, I hope though that I know we've all wondered why this happened, what was going on, and evidently, according to the first expert, I guess he did have some issues going on, but we'll hear all about that, everything, once all the evidence is introduced and stuff in the trial. And I do hope that somebody is there to stream it for us, and we'll follow that. I think that's where we will all, everybody who has watched about this case, that's where we all will get our answers. I'm hoping that we'll get the why, and we'll just get the answers that we've been asking for the past 2 years, And I hope he gets a fair trial. And I believe the Commonwealth, they're going to be able to do their job as a prosecution. As the prosecutors, they're going to be able to do their job. I believe they're going to get a fair trial. And I hope Mickey gets his fair trial too. I know that at one point, they had filed some motions, and they wanted the judge to recuse himself because some pictures had surfaced where him and Judge Mullins was at some meetings, some of the same meetings together. But he would not recuse himself from this case. So I'm sure a lot of people's going to be watching to make sure that he makes fair judgments in this case. and that no kind of hard feelings or anything is held toward the defense because of those motions. And, that was their right to make those motions, if they felt like that, he could have possibly been closer to the case than what needed to be. But he seems to think he's not. So, and we just got to hope and, pray and trust in that, he is being truthful about that. And I would imagine, that he is. He's a judge. I would hope. Because, this is a big case. And it's something, we never would imagine. I remember when I heard about it, actually, that was my husband's birthday. And we had went over across the state line and was having I took him out for a steak lunch. He wanted to go eat at a restaurant named Marino's, which it's so sad. It's recently, I guess it's a few months back, it burnt down. It was over in Norton, Virginia, Wise County, I think. Wise, Virginia. They're so close right there, that area, Wise and Norton, and I think it's Wise County, so it's a little confusing, but yeah, that restaurant burnt down. So I'm hoping we can find us another nice steakhouse, to be able to go enjoy sometimes. But I will quit talking and we'll get back to this. Get back to hearing Miss Sherry.
You said you were up all night with him.
Yes.
Okay. And at any point, did he go anywhere?
No, but he did try to get me, the daughter my mother adopted a child, and at the time she'd been at the doctor's office, had a headache, passed out, done MRI, she was in the bed. Well, Mickey at one point tried to get me to ride up by his house, just to check around his house and make sure it was all right, and he wanted me to leave her in the bed. Anybody that knows Mickey would have never suggested you leave a junior in high school in the bed by itself when it's dark outside to go check around somebody's house.
He wanted you to go with him to check on his home.
Yes, his home.
Had there been something that made him want to go out there?
There was a guy walking down the back street behind his house, and you could see his legs. And he was just walking down the alleyway, but it was enough to freak him out.
Oh yeah, I'd say that would freak me out too. Especially, if he's already, kind of paranoid. I know that one day I was at work. It's a different company that I worked for. And one of my friends was watching her camera. She checked her camera. And she actually saw a man breaking into her house on camera. And she called the police. So that's really good to have, where you can watch around your house from your cell phone. She called the police and they caught him still there. So let's go ahead and go on with this.
What did he think was going to happen, if you know?
Just my opinion, I think he thought they was going to circle around by his house.
And do what?
I don't know.
You said he was concerned about Caroline and Lila.
Mm-hmm.
And what was it about Caroline and Lila? Did he mention anything specific to them, what he was afraid of?
He was just afraid somebody was going to hurt him.
I heard him.
Yeah.
Now, you've known Mickey for a long time.
Mm-hmm.
His whole life?
Yeah, he brought him home from the hospital.
You familiar with his normal behavior?
Yeah.
What's Mickey like normally?
He's a jokester. He likes to laugh, play. He helps people a lot. He's a good guy. Hyperactive. He goes out and does stuff without you having to beg him to do it, or ask him. If he sees you need help, he'll help you.
Okay, we'll stop that just for a minute. And, I agree with her that is the type of man he was, he was a really good guy, is a really good guy. You know, the shooting here is the only thing, you know, that is out of character for him that I've seen. And let me say that I have seen. And Kevin, you know, he made some decisions, you know, that actually, I'm trying to see how to say this without not really. Well, okay, let me just put it this way. You know, he did some good things for me too, you know. I asked him to do something for me that meant somebody's life that I cared about, because they were very, very, very sick. They were close to dying. And he made that happen. So both men, they had their good qualities. And I know there's others out there, you know, and we've all heard the stories that say different things, you know, that they make allegations. And I'm not saying that their allegations aren't true. I don't know. You know, I've not had that happen to me. And if it did happen to the people who are making allegations, I really hate that for them. I hate that. I just know, you know, I just know what I know. And they both were really good to me and my family. And, you know, we liked them both. So, I just, that's all I can do is listen to the evidence, you know. So let's go on.
Was his behavior that night consistent with his normal behavior?
No, he acted different. I've never seen Mickey act like that.
If you had to describe how he acted in one word, what would you say?
One word, he was kind of psychotic.
Did he ever sleep?
No, why else would he?
What time did he leave your house?
He left the next morning. Now, I didn't look at the clock, but it was between 8 and 9.
Between 8 and 9?
Yeah, something like that. But I didn't look at my clock, but it was early.
And at that point, had he slept at all?
No.
Okay. Did you talk to Mickey anymore after he left your house that day?
Yes.
And let me back up. Was that September 19th of 2024?
Yes.
Okay. You talked to him again after that?
Yes.
How many times?
I think he tried to call me once, a voice call, but then he did FaceTime me once from the courthouse.
From the courthouse?
Yeah.
About what time was that?
2:49 maybe.
2:40.
Okay, so he had FaceTimed her from the courthouse. I do believe that was the person that he was, well, one of the people, you know, the person, he tried to call his daughter evidently, but then he actually, you know, tried to FaceTime his aunt, and I believe that's the person who he actually got in touch with, was his aunt. So I think that's who was on the FaceTime screen when you do watch that video of the shooting. It was right before that is whenever he had FaceTimed her. That's when she had got to talk to him again. So let's go ahead.
49?
Yeah,
And that's PM, I said.
yeah.
If I showed you a screenshot from a video, and Judge, this is gonna be a screenshot from the video of the Commonwealth is in this. If I showed you a screenshot of a video, do you believe that you could identify the person on the phone?
We can try.
That's
Judge,
her.
phone first.
Sure.
Jackie.
Are you wanting to mark that for the record?
No, Your Honor, I'm just.
Okay.
I'm sorry, say that again now.
To me,
You believe that's you?
yes.
And is that roughly the time? Let's see, I'm gonna go here. Apologies. Judge, if I can approach again.
Sure.
I have a time-stamped screenshot, Your Honor, of the video. 1438 is, I'm sorry, 1448. And that's you on the video?
Yes,
Okay. And that's the FaceTime call that Mickey made to you?
yes.
And is that about the correct time that you recall him FaceTiming you? On that FaceTime call,
And that was when he was in the judge's
what did Mickey
office.
say?
Well, like I said, my mother and daddy raised him, so he had a name for my mother. He called her Mommy Bones.
Mommy Bones?
Mommy Bones.
Okay.
And he called me and he said, Sherry, and I said, what? He said, let me speak to Bones. That's what he called Mommy.
Did you let him speak to Bones?
And she'd been dead 2.5 years. And I said, what? And he said, let me speak to Bones. I said, Bubby, where you at? Are you at the office? He said, let me call you back. I got a bad connection. I said, well, okay, call me back. He said, love you, bye. And that's the last time I talked to him.
That's the last time you talked to him.
That's the last time I talked to him.
Did you find that call concerning?
Yes.
Why?
He asked for my mother twice. He was with me when I had to unhook my mother from the ventilator. So he knew she was gone. It was me and him together, had to unplug it, so he knew she was gone.
Again, has Mickey ever acted this way in the past?
No,
Did you eventually find out what happened at the courthouse that day?
yes.
When did you find out?
It took about, till I found out for sure, about half an hour.
What was your reaction to that news?
My knees got kind of weak and my mouth fell open and I cried my eyes out.
Is that something that you could ever imagine that Mickey would do?
Never in a million years.
Yeah, I could have never imagined that happening.
Would I have ever thought that Mickey would even discharge his gun, let alone do something like that?
Has he ever been violent?
No.
Has he ever been angry, mean, rageful, any of those things?
You know, everybody gets angry, but I've never seen him violent.
No. Do you know if he's ever discharged his weapon?
Not that I know of.
Did you have an interview with the police after this all happened? And did you tell them that day what you're telling us today?
Yeah.
You said that you still have the Benadryl and the melatonin at your house.
Mhm.
Did the police come to your house?
No.
How'd you talk to them?
On the phone.
On the phone?
Yeah.
How many times did you talk to them?
Once was like an interview conversation, and then I think I may have had to call him back once after that because I remembered something. And they told me if I remembered anything to call him back, but I can't remember specifically what it was.
Okay, but they never came out to the house?
No,
They never collected any evidence?
no,
They didn't take the medication?
no.
That's surprising. It seemed like they would have taken the melatonin and the Benadryl. But, it is over the counter, so. But, okay, we'll go on.
You kept in touch with Mickey at all since he's been in jail?
Yeah, I wrote him a bunch at first, but now it's down to just like FaceTime, and I'll go up and FaceTime, with his wife, daughter, something like that. It's not as much as it was, but it's as much as I can.
Sure. You know how he's doing?
He's not doing good at all.
When you say that, what do you mean?
I mean, he's always had to take antibiotics every day of his life. He's got a really bad infection in his head. And it's not just looks-wise, it's painful, and it's getting on his face. His head's got these, it's hard to lay his head on pillows. He's in a lot of pain, is the point. And this tick bite he got has always caused him a lot of trouble.
Tell me about that. You said he got a tick bite?
Yes, they call it California encephalitis or something like that.
Do you know what that is?
He went to and from the hospital so much, and they kind of acted like it was a mystery illness. Like, oh God, we can't find it, just go home and take Tylenol. It just, his blood pressure would be up, it'd be down, and it was, he just looked beautiful. In that hospital bed, his feet hanging over him, acting like he wasn't sick, and they come to find out, run the test, that it really was something.
And what was it again?
It was from a tick bite. I think they call it California encephalitis.
California encephalitis?
Yeah.
And you have...
Okay, so she said that he had got California encephalitis from a tick bite, and that it was his blood pressure would go up and down.
Any idea? I know you're not a doctor, but aside from just being tired, being in and out of the doctor's office and things like that, do you know in any way how that affected Mickey? What symptoms he had, anything like that?
No, it had a lot to do with tightness in his head and stuff like that, I think.
Tightness in his head?
Yeah.
Okay.
Tightness in his head. I know it kind of sounds like pressure in his head, maybe. But, she used the word tightness, so tightness in his head.
Did it have any behavioral symptoms?
I don't know.
No. Okay. That's fair. That's fair.
But now he does have really high blood pressure. He was born with a heart murmur. And he's just always had a lot of health problems. Chest lot.
Okay, she said he was had high blood pressure, and that he was born with a heart murmur, and that he had a lot of health issues.
Heart, lungs, he had a hard time breathing. And it seems to be his health going down.
Health's going down.
Yeah.
Has Mickey lived in Letcher County his whole life?
Yeah.
Yeah, born and raised. You brought him home from the hospital.
Yeah.
Right, do his wife and kids live in Letcher County?
Yes.
Yeah. I think you already kind of told us when he was sheriff.
Mhm.
What kind of sheriff was he?
He tried his best to help everybody, if he could, to give everybody a chance. Tried to help turn their lives. He tried to help their families too. If they were having a hard time with their kids, he tried to help.
Mickey got any criminal record?
Nope.
Do you know if Mickey has a passport?
No.
Has he ever been out of the country?
No.
Ever been on an airplane?
No, I'd have never heard the end of it if he had.
Okay, so, he was the sheriff in Letcher County. And before that, he was the bailiff in Judge Mullins' courtroom. And he also worked over the home incarceration. He worked with a company that monitored the ankle bracelets that they would put on the people who were on home incarceration. And I had a family member that was, on home incarceration. And, he was over it, and he always did real good, with him. He was always fair. And that's, I guess where I got to know him a little bit more, at that time. But, he was always fair. And then I remember going to, when he was a bailiff, I remember going to court with one of my children, and I motioned him over. I had to ask him a question real quick, and he came right over. I mean, he's very attentive, When he was a bailiff, he done a good job, So, I mean, that's, how I know him, through little interactions, like that. And at some time, I'll go through and have a discussion with you all, why the person, was on the home incarceration and stuff, and then how God's turned that situation all around, and everything that Mickey done and Judge Mullins done, that was a part of it, and that the whole situation got turned around, and God moved on that situation. So let's go on back to the hearing, because I could keep on going, telling you guys stories and talking to you the whole time. So I'll try to keep it to brief moments if I possibly can.
As far as you know, what's his relationship like with Carolyn and Lila?
They seem to get along great. I mean, everybody has trouble,
Sure.
But can't live with each other, can't live without each other,
Ain't that how it goes? Can't live with each other, can't live without each other. I'd say a lot of people feel that way. And some people just get along, And some people can't get along, and, just have to go their separate ways. But, I believe they've been together for a long time.
Now, if Mickey were to get out on bond, does he have a place to go?
Yes, always.
Where?
Me or them.
They still willing to take you in?
Why, yeah.
You willing to take him in?
Yeah.
Judge decides to give him a bond, and he's able to make that bond. Do you think he'd comply with the bond condition?
Yes.
Would he show up for court?
Yes.
Would he take off and go to Mexico?
No.
Judge, if I can have this moment.
Sure.
Oh.
Okay, I'll just stop here and make a few comments. I don't know Judge Mullins' wife personally. Now, I have met Miss Caroline, Mickey's wife. She's a really sweet lady, and every time I ever, saw her, she was very nice.
You said you had written Mickey some letters and things from jail. You ever FaceTime with him?
Yeah.
And do you do that just you and him?
I go up to his wife and daughter's house, and then I FaceTime with him up there. Yeah.
How often do they FaceTime with him?
Every day.
Every day.
Yeah.
Now, you said, obviously we've gone over how he was acting the day before this all happened, the day of. Since you FaceTime with him, since he's been in jail, close to 2 years now, right?
Yeah.
Have you noticed any of those paranoid type of behaviors at all? Does he seem like he's pretty much back to baseline?
He seems pretty,
Even?
yeah. He looks really.
Okay, his aunt, Sherry Stein, seems to think he's pretty much back to baseline now. That he seems pretty even, is out now.
Bad, but I mean, he acts kind of calm now.
Say looks bad?
He looks bad, but it's really, he seems like he's calm now. He's not in the state he's in like this.
Fair enough. Judge, I think that's all I have for now.
Any cross?
Yes, Your Honor.
Okay, we're getting ready to have a cross-examination. No, not it.
I have a few questions for you, Ms. Stines. Let me make sure I understand this right. So Mickey wasn't acting right the day before to the point where you were concerned.
Yeah, he was acting, he was,
And did you call anybody?
no,
Did you call his wife and say, what's wrong with Mickey? Something's wrong with him?
no, he was,
And the next morning when you got this phone call, you didn't call anybody, you didn't call anybody at the sheriff's department, did you? And say, hey, something's wrong with Mickey, is he there?
no,
Did you? And you didn't call his wife that day either, did you? And say, Mickey's not acting right, he asked about bones, is something going on with Mickey? You didn't call her either, did you?
no. When he called and asked for my mother,
Yes, ma'am.
that was right before it happened, so I didn't have time to call
I
anybody.
think you said you had 30 minutes before you realized what had happened. See, in that 30-minute window before you realized what happened, you didn't call anybody, did you?
It had already happened.
Right, but you didn't know that.
No,
Okay, so you never called anybody between that
Sure
time and the
didn't.
time you found out.
no.
And you've spoken very highly of Mr. Stines, but my understanding is that he's concerned for his wife and daughter. Is that right?
Mm-hmm.
And he left them at home alone. With your house. Is that what you're saying?
Mm-hmm.
He didn't stay in the driveway. I mean, they were upset because he's walking around to keep them up. He didn't go to the driveway and set the car, did he?
I don't know if he did that or not.
He left and went to your house, correct?
Yeah, he did come to my house, but I don't know what he did before that.
Okay. And what time did you say he showed up at your house?
I don't know exactly. I didn't think it was going to be important at the time, so at the time I didn't notice.
Now, I think most people at this point in time, you've been arrested in Letcher County your entire life, haven't you?
Yeah.
And I assume you've seen this video also, haven't you?
What video?
The video in Judge Mullins' chambers.
Yeah, just once, part of it, yeah.
And you know who Kevin Mullins is? don't you?
Yeah, I know Kevin.
He's district judge?
I know Kevin.
He's a district judge, correct?
Yeah.
Was a district judge,
Yeah.
better way to put it. And you saw
I
Mickey
saw,
shoot.
yes.
So I know.
Thank you, ma'am.
But Judge,
Okay, we'll stop there just for a moment. You guys correct me if I'm incorrect on my verbiage when I said it's a cross-examination. And yeah, just correct me on that if I'm incorrect on it.
briefly,
Sure.
when Mickey came to your house, you knew that he'd been to the doctor that day.
Yeah,
Okay. And you knew that there'd been some concerns about his mental health.
yeah,
And that was the reason he was taken to the doctor.
yeah.
And when he was at your house, he kept the cameras on at his house all night long.
Watching his house.
Did he ever turn them off?
No.
Did they keep you up at night?
I could hear the little crickets and dark flies all night.
And was he concerned the entire time about what was going on with his
Yes, he
wife and
was.
daughter?
Yes,
I'll
he
have
was.
to.
Okay, she said he was concerned all night long about what was going on at his house.
All right, thank you, ma'am. You may have a seat. Any other witnesses?
Judge, I have a
And they have a shot of some of Mickey's family.
pretrial officer that interviewed Mr. Stines prepared to testify, but if the court can take judicial notice of its own report, then that won't be necessary. You can release that witness.
No objection to the report, Judge.
All right.
And in the back there is, the main back there is Jamie Hatton. I believe he was the Commonwealth attorney. I'm not really, maybe in the Letcher County attorney.
That's all the witness.
Anything from the Commonwealth?
Nothing, Your Honor.
All right. Ms. Barley, any argument?
This is Judge
Your Honor, I
Mills'
will ask the
family.
court, understand the court's ruling in order, I believe, in December, regarding the report from Dr. Allen.
Yeah,
I
and I
will,
will take that under consideration.
Yes, Your Honor.
That into this.
yes, Your Honor, thank you. That's absolutely an issue that we want to make sure we preserve. Judge, in terms of argument, it's the Commonwealth's burden to establish that the proof of Mr. Stines' guilt of a capital offense is evident, or the presumption of his guilt of a capital offense is great. Now, the cases say, and again, Markham v. Broughton sets the standard that says where conflicting evidence creates a plausible basis for self-protection, or the reduction of the offense to a non-capital degree, the Commonwealth has failed to meet its burden, and he's entitled to bail. Judge, the Commonwealth here, the only proof they've put forth is a video. And while I agree it's a compelling video, it absolutely is compelling evidence, Your Honor. Understand that. But the only thing that the video shows is an act and an identity. We don't have any element of intent. And the murder statute, Your Honor, anticipates, it actually makes an element, EED. EED is an element, or the absence of EED is an element, right? So they have failed, Your Honor, to put forth any proof as to the mental state, any premeditation, anything to that effect that would be necessary to take that and make it an aggravated capital offense. And our evidence, Judge, while it's been brief, we have Ms. Stines, we have the court taking judicial notice of certain pieces of evidence of the pretrial report. I believe that that creates enough of a presumption, Judge, or enough of a plausible basis, which is the standard under the law, to show that Mr. Stines acted in such a way that a jury could believe that he was either operating under extreme emotional disturbance or potentially even insanity. And I understand the court's ruling, again, on the insanity argument, right? That, you know, that's an affirmative defense. That's for trial. We're not having a mini trial here today on whether he is insane, whether he had the requisite mental state. But all of that proof, or the absence thereof, goes to whether or not he's bailable. And that's the only thing that we're looking at today. Did their proof meet that burden?
Okay, so the only thing that she's saying that they're looking at today is he bailable? So let's just take us a little break, and then we'll go on with it, and we'll see what the judge says. Okay. Yeah. You know, I'm, you know, I don't want to put my opinion in on anything, you know. And I'm sure everybody has thoughts and opinions on what happened, what they think could have happened, but we don't know, you know. None of us know until, you know, the trial happens. And, you know, that's the way I want to present this to you all. I don't want to present my opinions or somebody down the road's opinions. I think what we need to do is just listen to the facts and, you know, go from there, you know, and that's what the jurors will have to do, you know, listen to the facts. Even if, you know, they got to put, you know, their feelings aside, what they think happened, you know, because we've all heard all the rumors and stuff, you know, all kinds of rumors that wasn't true, you know, and then rumors that, I don't know, could be true. I don't know, you know, and that's the plain simple fact. I don't know. We don't know, and we're not going to know, you know, the truth until we get to trial. And hopefully it does go to trial, and that we will get the answers that we've all been looking for. And I hope you all, you know, I know there's other ones, you know, other people that come on, with strong opinions and stuff. But I don't, I don't want to be that way. I want to be somebody who can come, bring information to you and try to keep my opinions out of it. Try to bring the information and the facts to you and let you all make your decisions. We're all capable, and ultimately, we're not going to know it all. New things that's going to come out in trial. We're not going to know it all. So even if we make a decision, at this point, and we come out hard, that, hey, this is this and that's that, I'm trying not to make statements I've heard other people say. We're not going to know it all until trial. And if they do, if it does go to trial, which it's looking like it's going to, we still might not know it all then, But hopefully, the defense have put on enough and the prosecution have put on enough to give us a clear picture, of what happened. To give the jurors a clear picture. That way they can, make their decisions and have all the evidence and all the facts that they need. Sure, we could go with all the rumors and things, going on, but that don't help nothing, that just causes more drama for the families and stuff. Which, I know there's people out there that feel like, they've been wronged in certain ways. And I don't blame them for coming out and saying what happened to them. I don't, If that's what happened to them, more power to them to say it. That's the way I look at it. They can honestly come out and say, hey, this happened to me. Then let them say it. And bring awareness to it. So that's a thing, a lot of people's afraid to step out and say stuff. And when you live in a small community, like we do, it can be not a good thing, when you do step out and say something. But, who's going to take up for them? They've got to stand up and take up for themselves. If they truly, believe this happened, if it truly happened, they have to stand up for themselves. And more, like I said, more power to them. But all I'm saying is, I don't know what happened here. We all might think, but we don't know until we hear the evidence. Okay. And I hope, everything that I'm hoping, everything that I say, is biased. And I hope you all appreciate that, that you all understand why I'm doing it this way. And let's go on with this video from my friends at Court TV. Let me find our screen again. Okay, here we are. And we'll see what the judge says on this, on the bail, if he's bailable or not. Okay.
Now, I think evidence put forth by our single witness judge, and then of course what the court is going to take notice of, demonstrates that there is a plausible basis that this comes out of the capital murder arena. I think evidence that he was, Ms. Stines testified that he was acting out of his character, that he was paranoid, that he was having concerns about the safety of his wife and daughter. And the standard for EED, as the court knows, is it's not an objective standard. It's not a reasonableness standard, what a reasonable person would think. It's what he thought. What did Mickey Stines think was happening at that time? Why was he in fear? Why did he believe that his wife and daughter were in danger? And he clearly did. Now, the Commonwealth makes much of the fact that he left his house and he was at his aunt's house, but I don't think all that matters when you look at the mental state that he had at the time. He was completely out of his typical character. And, you know, the court will take a look at that video, and again, it's compelling, but I think there's so much more, Judge. And although the court, again, said that, you know, insanity is not necessarily relevant at this stage, the cases that we look at, there are several cases that say that bail should have been granted in a capitally charged case. And I think it is relevant that the Commonwealth hasn't filed a death notice at this point, right? So RCR, I believe, 402 says that.
Well, as we discussed earlier, that's being called advance at this point because there's outstanding issues in regards to that.
Sure, Your Honor. What I'm saying, Judge, is that.
Let me ask you this, Ms. Parker, because I do want to kind of move things along.
Yeah, absolutely.
What is the bond you're proposing?
Judge, what we requested previously was $50,000 cash for property, Judge, with any conditions that the court deems appropriate. The court has heard all of the proof on, you know, he'll have a place to stay. He's not a flight risk. He has no criminal record. He, in terms of the pretrial risk assessment, he's a low 0, the lowest that he could be. There's no reason to think that he wouldn't be compliant. He wouldn't reappear. There's no reason to think that he would reoffend, Judge. So we would ask for that, but with conditions. I think there are sufficient conditions to ensure his appearance, sufficient conditions to keep him and the community safe. An ankle monitor would be appropriate, Judge. No movement, GPS monitoring if necessary, no firearms, clearly. Yeah, I think the court can fashion any number of remedies to allow him to be out in the community and prepare his defense outside.
Okay, so the defense is laying out some different ways. It's a possibility for the court for them to let him out on bail, you know, an ankle monitor. I mean, it's ultimately up to the court. That way they're wanting him out on bail so he can prepare for his defense. Okay.
Out of the confines of Leslie County Jail. And so we would ask for that same bond, Your Honor, but of course, whatever the court deems appropriate, I was asking the court to find that he is in fact available and to set a reasonable bond.
All right, Mr. Steele.
Yes, Your Honor, I want to point everything she mentioned regarding the same.
Okay, this is not the defense. This is the Commonwealth, the prosecutor.
Those are all defenses, every one of them. We're not here for that at this point in time, but in regards to the bond, I'm going to point the court direction of Commonwealth v. Jones. I believe I gave the court the last time. It's 2024 Westlaw 2982769. And in that case, out of Breckenridge County, the Commonwealth chose not to seek that. And at that point in time, the circuit judge says that I'm going to grant a bond. There's a long analysis of that in regards to Criminal Rule 4.02. 4.021 says everybody is entitled to bond except those charged with a capital offense. And the conclusion, I'll read the conclusion in the last chapter. Jones was charged with a capital offense, which death was a possible penalty. Per Kentucky Constitution, Section 16, we believe it's incumbent upon the circuit court to make an express finding as to whether the proof of Jones' guilt is evident or the presumption is greater. One or the other. Accordingly, we reverse the orders of Breckenridge Circuit Court granting bond and setting conditions of release and remain the matter for determination of whether the proof of Jones' guilt is evident and the presumption is greater. If the court answers the question in the affirmative, then Jones is not bailable. The evidence is that Judge Mullins was a public official, which would make this a capital offense. So we do not believe he is a bailable defendant based upon the charges.
All right.
Okay, so the prosecution does not think that he is bailable based upon the charges. Let's see what the judge says.
Your Honor, if I may, just respond to that briefly. Jones, Your Honor, as the court knows and cited in its order that was dismissed as moot. I don't think the court ever reached the ultimate question, so it's still an unsettled matter of law, but the analysis is the same,
Sure.
Judge. So I don't think that case is really relevant at all to the court's analysis.
All right, I will get an order out on bond. I am gonna be real honest, the thought of a $50,000 cash or property bond is something the court would not entertain. If the court does believe that he is bailable, this would be a bond that would be much more significant than that. But I'm gonna hold that in advance and get an order out to you all in regards to that.
Yes, Your Honor.
Next, we've got a petition for change of venue.
Okay, let's see. The judge, I guess he's gonna review it and make his decision on whether Mr. Stines is bailable or not. So hopefully, it will be soon where we will know about whether Mickey is bailable or not. We'll know whether the death penalty, is on the table or if it's off the table. Let's go ahead.
Yes, Your Honor. To go to the Commonwealth's motion, we have attached 3 affidavits to that also. We've laid out the law for the case. I'm not going to go further. There was an attachment also, I believe, to the original motion showing also the news coverage, not just locally, but also nationally. I did just a little searching yesterday and updated some numbers. It appears the Mountain Eagle, which is the local newspaper for Letcher County, has had, at this point in time, had 103 articles written on this. They have a Facebook page, over 30,000 members on their Facebook page. I believe of the 103, I believe the number I got was 20 of those were speech or peace articles, in which people can just consider if they want to anonymously. And then there's comment, as you can imagine, in every direction. This was the top story in 2024, on both the Mountain Eagle website and on the Mountain Eagle Facebook page. WYT News, a local, I'm going to say southeastern Kentucky, has had 33 articles. News coverage in the last 12 months, I believe it is what I showed.
Okay, here Mr. Steele is discussing, talking about all the publicity that this case has had. He's talking about the Mountain Eagles. I think, I want to say he said 103 articles. It's this case, yeah, there has been, articles from the Mountain Eagle because, this is a local case. That's our local paper, our local newspaper. WYMT is our local news station. It is in Hazard, Kentucky. He's just talking about all the publicity, but this has been a national case, if not worldwide. Excuse me. I have been on a few different lives, and I have seen, people from different countries, being in those chats and having opinions and wanting to know what happened. And, I believe this is a worldwide case. It may not be as publicized in the different in the different countries as the United States, but it could be. I don't know. I'm not in those countries. But it's not just here in our county. It does mean a lot to people in the county. Because we never dreamed that something like this would happen, and it happened here. But that's what he's saying. They are proposing a change of venue, and it is the Commonwealth the prosecutors that are actually wanting the change of venue. It's not the defense team that wants the change of venue. They state that they feel that the Commonwealth cannot have a fair trial in Letcher County, and that Sean Mickey Stines cannot have a fair trial in Letcher County. And I will have to say that I disagree with that. Because, everybody wants to know what happened. But when the facts are presented, you can't ignore the facts. And my husband spoke with him, and he has a different opinion on it. That he thinks he's like, he just don't know if Mickey could get a fair trial here, or if the Commonwealth could. But I think that, to me, where it has been publicized, nationally, all over the world, in many other countries, people who know about this, I'm sure everybody has their opinions and what they think happened and stuff. But Mr. Stines and the Commonwealth, probably could get a fair trial somewhere else. But I do believe in the people of Letcher County, and that they will listen to the evidence. Which, I'm sure they'll run across a few that are just stuck in their way, and that's the way it's going to be. But, most people, I feel, will listen to the evidence. I feel like, this is my personal opinion, and my husband's differs, because he just don't know for sure. I feel like that there can be a fair trial in Letcher County. And to me, I kind of take that as an insult to the people of Letcher County, but, and I've been trying to keep my opinion out of it. But I do feel like, they may have to go through a few, but I do think they could see a jury, that would be fair and impartial jurors. That's my belief. It's ultimately up to the courts, what they decide. But, okay, we will go on. That way I will keep my opinion to myself.
And I'm not going to say what people say, because obviously I'm being quoted.
Sure.
But suffice it to say, a large number of the community has strong feelings one way or the other. And it's just not in Letcher County. I was had a conversation with Victor's family in Perry County just 2 weeks ago. And of course it came up. And he was very strong with his opinions as to what it was. Not just based on news stories, but based on just rumors and word of mouth, and some outlets that, I didn't get into the YouTube bloggers, which has been insanity, to say the least, in regards to theories and things they are saying out there. I believe the defense counsel's even commented on some issues as not being true, that have come out in those. It's our position, Judge, that the news media coverage in southeastern Kentucky, and even central Kentucky, because the IMT has, they're a sister station to the Lexington channel, the coverage has just been unbelievable. I can go into Facebook pages all over southeastern Kentucky and find strong opinions.
Well, yes, the coverage has been unbelievable, and it's been unbelievable all over the world, not just here in Letcher County. I mean, it's something that just don't happen, but I do believe, I mean, there has been rumors, all over social media and stuff, and that's just what they are, they're rumors. We don't know the truth, until it comes, the facts come out. And I believe, there's a lot of people who have that mindset, You hear the rumors, but it's the facts. Whatever the facts are, that's where you have to make, you got to draw that line, Okay, that's a rumor. These are facts. This is what it shows happened. And I think it's, and I think a lot of it is just where people didn't know what happened. Nobody knew, exactly. Well, nobody really knows the full reasons why it happened. We're starting to get bits and pieces, through the hearings and things, but and that sparks a lot of rumors.
The market changes when you get in Western Kentucky in regards to where their news has got where they receive their news. You really receive news out of the national network and not the Lexington or South Kentucky network. So that's our position, Judge. The affidavits are of a practicing attorney, of the county attorney, and the county attorney. The county clerk and the circuit clerk weren't available the days I was over there. I think they realized what was on the docket and they both got out of town. So those are the people that I could catch up with. I can tell you I could get these signed by almost anybody in Letcher County. And these individuals that ran for office have a finger on the pulse.
Thank you, Steve.
Let me just say here, I'm just looking at this from my point of view. I would rely on the facts. Yes, I've heard the rumors, but I would rely on the facts of what happened. And that's the reason I said I feel like it's an insult, because I feel like it's an insult to me as a resident of Letcher County that they think that I could not do that. And I'm sure, there's, like I said earlier, I feel like that there may be a few, are just going to stay stuck in their ways, but that's the reason, they had those interviews with the jurors beforehand. It happened here in Letcher County. I would like to see the trial here in Letcher County. I do want to see, both the Commonwealth and Mr. Stines get a fair trial. I feel like that could happen here in Letcher County. That could happen in other counties. But it does have to be, I think, I'm not, I've never went to law school or anything like that. But doesn't it have to be a jury of his peers? Am I incorrect on that? But like I said, it is totally up to the judge, on the court and what they decide on that. But I do believe, if I'm not correct, let me know, but I do believe that it has to be a jury of his peers. And to me, it should be, in an area, if not Letcher County, it should be in an area where they have the same background, so to speak, like I said, a lot of people have strong opinions and stuff, and I'm trying to keep my opinion out of it. That's one thing though that I did want to touch on, is that, I do feel like there's other people in Letcher County that feels like me, that they will listen to the facts. It's not, to me, it's not that Letcher County is incompetent of having a jury for this trial. I don't think it's that. And it's totally up to the judge, in the court, what they decide. But, I do feel like, and it don't have to be here, it's up to the judge. But I do feel like Letcher County there is people that's competent at being fair and impartial. I just want to see I just want the facts to come out, and for it to be a jury of his peers, and possibly, have the same background, and kind of live the same lifestyle. I'm not sure how important that is, but it could be. And, I think maybe people with Appalachian mindset, there's different mindsets in different areas, But my whole point is, I'm sorry, we need to get back to this, but my whole point is, I feel like I could be impartial and fair. So, and I believe there's other people in our county that could be also, and that I just want to make that point. But, there's other counties that they could be fair and impartial too. I'm glad it's not my decision. And I really hope that the judge, makes a good decision on that, whichever way it may be. Just as long as, both sides get a fair trial and get to present the evidence and the facts. Let's go ahead and go on.
Yes, sir. Judge, we had subpoenaed the people that had signed the affidavits with the change of venue, and I think one of them is Miss Ashley Fields. If I could call her.
Sure.
Okay, the defense is calling Miss Ashley Fields, but I think she may have kept her last name as Sturgill to the stand.
Is Ashley Fields here?
Yes, sir.
Thank you.
Ma'am, if you would raise your right hand and swear. Do you swear from the testimony you give me the truth, whole truth, nothing but the truth?
Yes, I do.
Please state and spell your name.
Ashley Sturgill, ASHLEY STURGELL.
Well, I'm sorry, I thought it was Fields. I don't know where I got that.
I'm married, but I did not change my name.
And you state your name for the record. Where do you live?
I live in Whitesburg in Letcher County.
And is that like, do you live in the community, or do you live in town there? Or
In the community, in town.
what is your community's name?
I live in Whitesburg, in the upper bottom there.
Okay. And have you lived there all your life?
No.
How long have you lived there?
I've lived there for approximately 3 years.
3 years.
Yes.
Now, let me ask you, do you work anywhere around the courthouse or anything like that?
I'm an attorney in town,
Okay, and what kind of law do you practice?
general practice.
Okay. And did you happen to be in the courthouse the day of this occurrence?
I did, yes.
And so you could technically be kind of a witness.
Yes, that's
Would that be
correct.
right?
Yes.
And did you have any emotional feelings about this?
I was there that day, so I think,
Did it shake you up?
of course,
Okay.
yes.
And so when would you have moved to Whitesburg there?
I think I moved in the fall of 2022.
Okay. So you lived there approximately 2 years, would that be all right, at the time of this occurrence?
Yes.
Okay, in that same place?
Different places in town. I've lived several places.
Oh, okay. Let me ask you, you state in your affidavit there that, in support of this motion to change the venue, let me ask you, what public opinion, how many?
Okay, what they're talking about here, they're calling people to the stand who signed affidavit wanting to change the venue from Letcher County to another location.
People are in a public opinion.
I think it refers to the state of public opinion.
Well, that's what I'm asking. Let me
Yeah.
show you what you signed.
I've got a copy of it,
Okay.
so.
Well, I just wanted to know, how much?
Sounds like the audio is cut out there on us. I'm sorry, guys. And again, he's asking her about where she had signed the affidavit wanting the trial moved to a different county instead of Letcher County. Let's see if we can go on to where the volume picks back up. There we go.
Do you practice any criminal defense, anything like that?
Yes.
So you understand, when you said that the Commonwealth couldn't get a fair trial, is that right? That you said even they couldn't?
I think I said both.
Both
neither
parties,
party
well,
can get a
neither
fair
party
trial.
could get a fair trial. I'm just going to talk about the Commonwealth.
Yes.
You understand it as a criminal defense, somebody that does that you start off with a presumption of innocence in every criminal case.
Yes.
Presumption of innocence. So already the Commonwealth has got a burden to go over to overcome that presumption of innocence. Is that right?
That's correct.
Okay. And what to you is a fair trial for him, Mickey Stines?
Again, I don't believe either party could get a fair trial in a community where you have a victim and a defendant who were both elected public officials in
Well,
that community, which inherently brings with it a lot of love and a lot of hate and strong opinions toward either.
Okay, but I'm just saying, in a trial, could you understand why a person would want to be tried in their home county?
I can see why people would want to, but I
Okay.
can't see why anyone would want to in this situation.
And in this public opinion that you talk about, have people expressed to you that no matter what we hear in that case, in that trial, we're never going to believe anything the Commonwealth has to say?
Excuse me, can you repeat that?
Has any of those people that you said have public opinion,
Mhm.
has any of them expressed to you that no matter what is said in the trial, I'm not going to believe anything the Commonwealth puts forward?
There are people who have taken strong stances on either side,
But
very publicly. Now, do I think that someone would come in and admit some sort of inherent bias? No, I don't think that people even realize that they have that usually.
Mhm.
I don't think someone would walk in here in front of all these people and admit to being racist, for example.
race isn't an issue in this case.
I know, but I'm just
Okay.
saying, those types of inherent biases, I don't think people would be willing to just freely admit to that.
True, but that's in any.
But, okay, would they truly admit to that anywhere? No. I just, I disagree. I think that people of Letcher County would be honest. And if they feel like that they could not sit on that jury, that they feel like they cannot take the facts into they can't look at the facts instead of having their strong opinions, I think they would say that. Because, you know, if they're going to have a strong opinion about it, I do believe that, you know, the people of Letcher County, you know, could. Be fair and impartial jurors. I really believe that. And if there's some that just simply, you know, is stuck in their ways and can't change their mind, I believe they would be honest and say that. But that's my personal belief. Okay, we'll go on some more.
Case you try, no matter what kind of case it is.
Correct, where there's some sort of bias.
There might be a bias about anything. True. And all the court can do is ask, all we can do is ask questions and go by the answers that the people give, right?
Correct.
And you're not here saying that the Letcher County people would give false information under oath about on board hire, are you?
No,
Okay.
what I've just said is that, and I'll repeat that, I think that most of the time when people take strong stances, they don't even realize the bias that they actually have.
I understand, but no matter what,
Yes, I agree that the Letcher County people will not make false statements under oath. That even though that they may take a strong stance, I personally, you know, I believe that they will say, "Hey, this is how I feel." You know, that's my opinion. But you know, this is ultimately up to the court. And let's see. See the defense. Let me go on. See what the judge has to say here. Well, here, let's see. I believe this is the end of the prosecutor, Commonwealth prosecutor, talking to Miss Sturgill.
And he's just concentrating on the Commonwealth not getting a fair trial. Does he say Mickey Stines
No, she wasn't at the podium, so I skipped over that. Okay, go ahead.
has a presumption of innocence, right?
Yes.
Is it your position that if it was to be tried in Letcher County, that Mickey...
Oh, I think she is at the podium. I thought I seen a little glance of her not being there.
Stines would not have that presumption when he walked into courtroom in front of the jury?
I don't.
objection, Judge, objection can be approached eventually.
Sure.
Okay, they're approaching the bench there. Okay, let's see. We will go on. Skip through this just a little bit. They're still talking to her, you know, about where she had signed the affidavit. Okay, so here's another witness. Another person who signed the affidavit that the defense is calling it.
At least every week in Letcher County.
Yes.
In your opinion, in your conversations with the citizens of Letcher County, is there anybody you've talked to yet that hasn't expressed or formed an opinion on this case?
There have been people who, of course, they want to ask questions,
Sure.
but, I think that for the most part, I feel that for the majority, people have formed an opinion already.
All right, thank you.
Thank you. Thank you, Your Honor.
Any other witnesses?
Mr. Jamie Hatton?
Jamie Hatton? Sure.
Yes, sir.
And he should state what his role was, because I
All right, Mr.
wasn't
Hatton,
sure the
if you
correct
raise your
title.
hand, you sworn, do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You put your hand down, please state and spell your name for the record.
Jamie Hatton, JamieHatton.
All right, thank you. You may ask,
Thank you,
counsel.
sir. And Mr. Hatton, where do you live?
Whitesboro.
And do you hold any position, elected position or anything like that?
Yes, I'm the Letcher County Attorney.
Oh, okay. Who asked you to sign a petition for a change of
Mr. Steve.
Okay, so he's a Letcher County attorney, and then he said Mr. Steele asked him to sign the affidavit for a change of venue.
And as the county attorney, did you kind of recuse yourself from any prosecution in this case?
No, never came up.
Okay. I didn't see you at the preliminary hearing last day. All right.
I was Mr. Stines' attorney at the time of the commission of the offense, so.
You were?
I was.
I understand. And let me ask you, when you say community, how many people is there in Whitesburg?
About 7,000 people in the city limits, 20-some thousand in the county.
Okay. Now, you certainly hadn't talked to every one of them.
Nope.
Okay. How many do you guess you talked to about this case?
To guess, hundreds, I would imagine.
Okay.
Let me back up
And
here just a minute.
I know that.
I was wanting to hear what he said there.
As the county attorney, did you kind of recuse yourself from any prosecution in this case?
No, never came up.
Okay. I didn't see you at the preliminary hearing last day. All right.
I was Mr. Stines' attorney at the time of the commission of the offense, so.
You were?
Okay, that's what I thought he said. If I understood him correctly, I think he said he was Mr. Stines' attorney at one point. If I heard correctly. You want to hear that one more time? See if I got it back there.
As the county attorney, did you kind of recuse yourself from any prosecution in this case?
No, never came up.
Okay. I didn't see you at the preliminary hearing last day. All right.
I was Mr. Stines' attorney at the time of the commission of the offense, so.
You were?
I was.
I understand.
Yeah, I
And
think that's what he said.
let me ask you, when you say community, how many people is there in Whitesburg?
About 7,000 people in the city limits, 20-some thousand in the county.
Okay. Now, you certainly hadn't talked to every one of them.
Nope.
Okay. How many do you guess you talked to about this case?
To guess, hundreds, I would imagine.
Okay. And I know that, has anybody just said that I am going to not believe anything the Commonwealth says about this case?
No one said that.
No one said that.
Not to me.
Anybody said, no matter what's said, no matter what's done, I'm going to find Mickey Stines not guilty?
No one said that to me.
And you agree he has a presumption of innocence?
Sure.
Okay. And so you're a prosecutor, right?
Yes, I've sat at this table and at that table as well.
Okay, I got you.
Sure.
And what is a fair trial for the Commonwealth? What does that mean? If he has a presumption of innocence, you already start with something right off the bat.
I think fair is subject to the eye of the beholder. You know, what's fair mean to you?
Well, that's a good question. But I was just going to ask you this. Would it be important, do you think, now Mr. Stines hadn't asked for a change of venue. Do you think it's just about equally as important that he be allowed to stay in his own county and place his trust in the people of Letcher County to judge his case?
Sure.
You think they can?
Think who can?
Do you think the people of Letcher County can judge his case fairly?
I mean, I've got a great respect for the people of Letcher County, but I couldn't imagine, you would almost have to have 20,000 jurors in there to try to find 14.
Well,
You know what I mean? I don't have a really strong opinion.
I understand what you mean.
Yeah.
But, I mean, do you understand, should a person be able to be, those people put their trust in Mr. Stines when they elected him. Mr. Stines put his trust in them. Do you understand it would be important to him to be tried in his own county?
Yes.
And they would be fair.
I don't know if they could be or not, honestly.
Okay. Would they be honest and say, no, I can't be fair?
How can you say? You've done a lot of voir dires.
Yeah.
I mean, we're honest with you.
I understand.
Yeah.
But that's a chance we have to take.
Sure.
Judge, that's all I have.
few questions, Your Honor. Maybe how long have you been county attorney?
15 and a half years now. We're halfway through this year. Yeah.
So,
Okay, what we're hearing is Mr. Steele talking to Jamie Hatton, the Letcher County attorney.
you obviously politic a lot in Letcher County, you know a lot of people in the community.
Yes, sir.
How long have you resided in Letcher County?
Other than the 8 years I was off to school, all of them.
Or even when you was at school, your mom and dad lived there?
Absolutely.
Families from Letcher County?
Yes.
Have roots going back to Letcher County, all over Letcher County, don't you?
Yes, indeed.
And again, is there people in your community that you, and how many, as a county attorney, I don't even want to fathom, how many people you talk to in a week?
I would say, you mean just in my work?
Just
or
in general,
going to-
yeah, not county family, but just people walk on the street, people calling the office, people wanting to visit your office.
Probably 100 or more weekly, sure.
And you have a private practice also, don't you?
Yes.
And so you deal with car wrecks and other litigation, other than just criminal prosecution. So you have
Sure.
clients, not just from the criminal world, not just officers coming in, but you have other clients coming in for wills and estates and all that, those probates.
Yes, that's true.
How often does conversation turn to this case?
Well, for the first probably year after it happened, pretty much the first time I'd see someone, and talk to them, they want to talk about that.
Well, because you're the county attorney.
Sure, yeah. And then whenever I'm in court anywhere else in the Commonwealth, that's the first thing. Oh, you're from Letcher County. They want to talk about this case. So.
Okay, so he made a point there. It's anywhere he's in court, they want to talk about it. So it's not just here in Letcher County. It had, a lot of it's died down, and I think it's just people are waiting to hear the facts. But, it's not just, it's just a point I want to make is, yeah, people here in Letcher County are curious, just like other people in the other parts of the state and nationally. They are curious what happened, what caused this to happen. I guess is what we don't know, and it's going to come down to us hearing the facts. Okay, we'll go ahead and go on.
Yeah.
So it comes up frequently.
Yes.
Not as much today, I guess, as it did the first year, you said. In those conversations, you're just talking about the people of Letcher County, not in other counties or talking about attorneys, because they're always inquisitive. When you're talking to these people in Letcher County at ball games or cookouts or fire department raffles, whatever, how often does this still come up?
Really, every time a hearing or something like this comes before the court, it pops right back up to the conversation of the day, and then.
Yeah, I agree, whenever, it has died down, but, like if a hearing or something that goes on with the case, comes up, that, it kind of grabs people's attention again, I mean, it's always in the back of our minds wanting to know what happened. And, like I said, we just got to wait for the facts to come out in the trial. And, like I said earlier, both men had good qualities, Both men, had been good to my family. So that's where it comes down to with me, would be the facts. But let's go ahead and keep going on with this.
It'll fade into the background and come back.
When that next article comes up, there goes the.
That's it.
Do you subscribe to the, and I hate to put you on the spot, do you subscribe to the local newspaper?
Yes, I do.
And have you seen articles on this?
Oh, yeah, lots of them.
Do you also check their website, read articles on the website?
I used to more. Now that I've got the subscription, I just read in the paper for the most part.
Can you tell us if you're familiar?
Okay, that's Mr. Steele. He's asking Mr. Hatton about if he subscribes to the Mountain Eagle, the Letcher County paper, you know. And then he was asking him if he goes online, looks at it, and things.
What is the Speak Your Piece?
It is a sort of it's really cool, but it's a local opinion thing. Anyone, anywhere can call in and leave a message, and they'll post it in the newspaper. Yeah.
And then,
Yeah, that's something we've always had in our paper for as long as I can remember. It's Speak Your Piece. It's like Mr. Hatton said, you know, you can call in and make a statement, and you know, the newspaper will usually print it. I'm sure, you know, it can't be, well, no, I've never seen any bad words or anything in it. It's just like something where you can state your opinion. And I've seen, this is just for instance, I've seen like in Letcher County, people call in and say, you know, why ain't the cops watching this area? You know, there's drug dealings going on here. They need to be watching this. Or they'll say something, you know, how they feel about the president. Or they'll say something about, oh, this person's cheating on this person in this place. Name a place, but they don't put, you know, no names. You know, it's just whatever that they're put, whatever they want to call in to speak your piece. And that the newspaper will decide if, you know, they will publish it or not. Usually they publish all kinds of things, even like what I just told you. You know, some of it may just be straight out lies, you know. But, and then some of it's just, you know, people's opinion and what they see and how, you know, maybe they're wanting to tell on somebody anonymously in the paper. But you never know, you know, if it's somebody lying or what. But yeah, we do have that, and it's in our local Mountain Eagle paper. It's called Speak Your Piece, and there's a phone number. I'm sorry, that's my dogs. And there's a phone number that you can call into and make a statement and just do it anonymously. Okay, we'll go ahead with the rest of this because he was explaining about Speak Your Piece.
on the website.
We'll post it in the newspaper.
We publish it in the newspaper. It has a whole section.
You can call in anonymously,
Yes.
leave a voicemail, and publish it in the newspaper.
Correct.
And in regards to online, you can actually make comments to that, can't you? Have you seen that? Are you aware of that?
No, I've never seen Speak Your Piece online.
Okay, fair enough. I want to ask you more on that. Jamie, in regards to the hundreds.
Okay, I think he's saying that there might be a place where you can make comments online to Speak Your Piece. I'm not sure. I've never really looked for that. Never call in to Speak Your Piece or anything like that. I've read it before though. But he's saying that you can go online, but you would have to go to the Mountain Eagle newspaper and look and see if it's true or not, that you can go online and be able to submit a comment to go in to Speak Your Piece anonymously.
Thousands of people you've talked to in the community in the almost 2 years since it's come about. What do you think the percentages are of people that have made their mind up or have very strong opinions one way or the other?
I couldn't say a percentage, Mr. Steele. It just seems like there's a very strong Team Mickey, and there's a very strong Team Judge Mullins. You know, lots of people tend to fall on one team or the other.
And I think you said you'd have to have 20,000 people, you get 14 that's going to fall in the middle.
Yeah.
Let me ask you, Jamie, in regards to Team, you said Team Mickey and Team Judge Owens, are they pretty rooted in their position?
Seem to be, you know, they really do. They seem to be from the start, from the outset. People started teaming up, it felt like. Yeah.
And as a county attorney and as a public defender, do you see changing venue as appropriate in this matter, based on your understanding, not only the people of Letcher County, but also of the rule of law?
Yes, that is my opinion. Just for judicial economy, for one thing. We can bring the circus back to town and try and do this, and just, you'll just end up having to go to another venue eventually. However many times you want to set it for trial in Letcher County, you know, it just doesn't seem.
Okay, so he feels like that it would be hard to seat a jury in Letcher County. That, you know, there's a Team Mickey and a Team Kevin Mullins, Judge Mullins, and we're all entitled to our own opinions, you know. And you know that, you know, I guess that's how he feels, and I guess that's how Miss Sturgill feels, that there can't be, you know, a jury that would be, well, that it would be hard to pick, you know, to sit a jury. I'm assuming that's what they're saying. It would be hard to pick a jury. Not that it can't be done, but that it would be hard to pick a jury.
Feasible.
And you've been through the 4-hour process, picking a jury multiple times in Letcher County, haven't you?
Yes, I have.
Oh, I don't.
All right. Steve Paul.
Just a quick follow-up.
Sure.
Mr. Hatton, I heard that you had been Norland County attorney for 15 years, been a public defender.
Yes.
How many times have you filed for a change of venue?
Never.
Never. So you didn't have any high-profile cases or any cases you ever worried about?
Nothing like this. Nothing like this.
All right.
Not even close.
And how many times have you ever seen that the Commonwealth filed for a change of venue?
First time I've seen it.
And I think you said whenever you go out of the county especially, people ask you, and then when they find out you're from Letcher.
Yeah.
Is that because you're with the county attorney's office, or just, I'm a citizen of Letcher County?
I don't know.
Don't know.
You'd have to ask them.
Okay, I got it. And can you see, no matter what, I know you said that this could be a terrible situation, but did you ever know of any cases that were real high profile that they tried them right there in that county that it happened? No matter how high profile.
I would imagine this is the highest profile case in the history of our little county.
Yes, but I'm just saying high profile cases. Did you ever hear of that case in Pulaski County where the sheriff got assassinated?
No.
Legit?
Okay.
We trial, we'll trial.
Okay, and this video is from our friends at Court TV. As Mr. Jamie Hatton, the defense had called him, and he was one who had signed the affidavit, you know, thinking that the venue should be moved from Letcher County, and you know that he's got the right to have that opinion, and so does Miss Sturgill. She has the right to have her opinion. My husband has the right to have his opinion, which he's like, you know, kind of iffy. He don't know, and I think we could, you know, I really do. I feel like they may have to go through quite a few, you know, like he had said. We have to go through quite a few people, you know, because some of them might not change their mind or, you know, want to just listen to the evidence. But then there are some like myself, I would listen to the evidence. Okay, we will go on. Let's see.
That's all. That's all.
All right, thank you, sir. You're released from your statement.
May I
Yes, sir.
thank you.
Judge, if you'll
Okay, that's all from Mr. Hatton.
permit me, I'd like to call out the name of just one more person to make sure they're not here, and that would be Mr. Matthew Butler.
Is Matthew Butler in the courtroom?
Okay, Mr. Butler, I guess he was subpoenaed to court. You know, he was one who had also signed the affidavit to move the trial from Letcher County, and you will hear later on in this video that him and Judge Mullins used to be married to a pair of sisters, and Judge Mullins was still married to his wife, and Mr. Butler used to be married to her sister. So you'll hear that later on in this video. And let's see, I think that they will take a recess, and we'll try to skip past that, which they may already have the video fixed where it does skip past that, and they call Mr. Butler on the phone, and he, I guess, testifies over the phone.
We approach the bench on that matter.
Okay, approaching the bench. Let me see if they skip. Oh, they're still at the bench. Let's see if they skip over the recess, because we don't want to take up too much of your time. Let's see, yeah, they're going to recess right here. And we'll just skip over this because it's just showing the people, you know, in the courtroom, and then okay, we'll go on through here. Okay, let's see, is it coming back yet? Not yet. I'm just, you know, I just want to be biased. And I do want, you know, a fair trial put on. I think they, you know, might.
Can you hear me okay?
Okay, hold on just one moment. I think, you know, there may be an issue in Letcher County, but I think it can be done, you know. Like I said, there was a Team Mickey and a Team Judge Mullins. You know, those people who take sides, you know, according to what they've heard, you know, and you know, I'm sure, you know, there's rumors that they've heard and stuff. But that's not saying that they won't sit and listen to the facts, you know, and the evidence, you know. I mean, if they're capable of doing that and making a decision based upon the evidence, and that just not for Letcher County, it's for everywhere, everyone that's heard the rumors and stuff, they're going to have to put that aside. Not just Letcher County, everywhere. Wherever if the judge and the court chooses to move this venue, you're going to face that also. Maybe not as much as you would here in Letcher County, but, you know, once the people hear the news, and like I said, it's worldwide, not just nationally. If they heard the rumors and they've watched some of the YouTubers and stuff, you know, that voices their opinion, then they're going to have to set that aside to be able to be a fair and impartial juror, regardless of where you're at. Okay, they're coming back here, and I think it's going to be Mr. Butler's testimony.
All right, counsel, you're approaching.
Yes, sir.
Yes. All right, sir, if you will, please state your name for the record.
Matt Butler.
All right, Mr. Butler, your first going to be question on counsel on behalf of Mr. Stines. Go ahead.
Mr. Butler, would you state your full name?
Matt Butler.
And what position do you hold in Letcher County? I'm sorry?
Go ahead with the question.
I just want to ask, what position do you hold in Letcher County?
I'm the Commonwealth Attorney.
And how long have you been Commonwealth Attorney?
July 1st of 2024.
Okay, so Mr. Jamie Hatton is the Letcher County Attorney, so I wasn't really sure which way that went earlier. Mr. Jamie Hatton is the Letcher County Attorney, and Mr. Matt Butler is the Commonwealth Attorney. Okay, we'll go ahead with this. Listen to Mr. Butler's testimony.
Mr. Butler, I guess I gotta ask you, you know, we tried pretty hard.
We don't need to discuss
All
the
right.
Sting issue, ask your question.
Okay. Now, let me ask you, you signed an affidavit, who asked you to sign an affidavit for a change of venue?
I believe that was the Commonwealth.
Okay, and how many changes of venue as you as a prosecutor have you asked for?
None.
So you don't have, as you said here today, you don't have any issue with the, I guess, fairness or the ability to trust the Letcher County juries, do you?
I don't understand the question.
Well, do you have, as you said here today, do you have any trouble in relying on the truthfulness and the fairness of the Letcher County jurors?
The question of whether or not Mr. Stines can receive a fair trial and whether the Commonwealth can have a fair trial is based specifically on that case. It is a case-by-case approach. If there were a case where a defendant could not have a fair trial and the defense wanted to move it, I would not object to that. If the Commonwealth cannot receive a fair trial in the case, I would move to change venue on behalf of the Commonwealth. But it's a case-by-case approach. This case is unlike any other that has happened, to my knowledge, ever in my circuit court, but certainly the conduct in the Commonwealth Attorney.
All right. Can you tell me what exactly is a fair trial for the Commonwealth?
A fair trial for the Commonwealth would be one where the Commonwealth feels like they have just as much of a shot of getting an unbiased jury as the defense does.
Okay. And if the jurors could said that they could follow the judge's instructions and follow the law, would there be any problem with that jury?
You're asking about whether or not that could happen at the time you're taking a jury in Letcher County. And my affidavit supports my opinion that you couldn't even get to that point, that there is no way to see a jury in Letcher County, Kentucky on this matter.
Is that based on your personal talking with people or just on like the coverage?
I live in Letcher County, and I've seen the concerted effort by you, your investigator, and others to paint the jury pool, and I feel that it is extremely unfair that you have taken great steps to imply that there's some sort of conspiracy that there's not, and the Letcher County jury could not see this matter. Also, the big...
Okay, Mr. Matt Butler is testifying that he had signed the affidavit, and from what we've heard, he does not think that the Commonwealth or Mr. Stines, if I'm saying this, cannot get a fair trial in Letcher County, or that they couldn't seat a jury in Letcher County. Excuse me, I think that's what he said, that they wouldn't get to that point to be able to even seat a jury in Letcher County. So, you know, that's his opinion.
The murder victim was an elected official, and the sheriff was an elected official.
Okay. Now, let me ask you something. You didn't, Mr. Steele is the prosecutor in this case. Did you just voluntarily withdraw to get off this case?
Within about an hour of finding out that your client had killed our district judge, I had spoken with the Attorney General's office, and they had reached the same obvious conclusion that I was, that it would be better for a prosecutor from outside of Letcher County to sit in this matter.
All right. Finish your statement.
Okay. So he said that he had spoken to the what was it, the Attorney General, that it would be better to have a prosecutor outside Letcher County. Let me see if he says Attorney General, if I'm saying that correctly.
This case is unlike any other that has happened, to my knowledge, ever in my particular court, but certainly in the time that I've been the Commonwealth attorney.
All right. Can you tell me what exactly is a fair trial for the Commonwealth?
Okay, I think I went back just a little too far. I'm sorry, guys.
Did you just voluntarily withdraw to get off this case?
Within about an hour of finding out that your client had killed our district judge, I had spoken with the Attorney General's office, and they had...
Yeah, the Attorney General's office, okay.
That it would be better for a prosecutor from outside Letcher County to sit in this matter.
All right.
Sure. 1 second, please, sir.
Defense is going to ask
Mr.
something
Butler,
else.
I'm back. Were you ever related to Mr. Mullins?
At one point in time, from December of 2014 until July of 2029, he and I were married to a pair of sisters. During that period of time, I did not practice in Letcher County.
Okay. All right. Thank you.
Mr. Steele.
No questions, Your Honor.
All right, Mr. Butler, thank you for your cooperation.
Thank you, Judge Butler.
All right, any other witnesses?
No, Your Honor.
All right.
Okay, let's see, that was the last witness that the defense is going to call in this hearing. Let's see, I think the judge is going to make his decisions, you know, what he's going to do.
Anything else on behalf of the Commonwealth?
Nothing further for help this issue, Your Honor.
All right. Any argument, counsel?
Judge, if I could read from the case, the mere fact that jurors may have heard, talked, or read about a case is not sufficient to sustain a motion to protect the opinion. Absent of showing that the accounts and descriptions of the investigation and judicial proceeding have prejudiced the defendant. That comes from the case Commonwealth versus Ronnie Lee Bowling out of the Laurel Circuit Court. It's cited at 942 Southwest 2nd, 293. And the reason I'm citing that case, Judge, I was the attorney in that case. Very serious case. And at that time, that was back, of course, this decision wasn't done until 1997, and the actual offense itself didn't occur until it was much earlier, sort of earlier than that. And London was a small town, pretty small town by then.
Okay, the defense is talking about a case that he had, he was an attorney in the case. I thought it was going to go to the judge's decision, but yeah, I forgot he had spoke again.
And it's growing some now. And I remember there was a lot of coverage, there was all kinds of talk, everything else. It was 2 robberies, 2 murders.
Okay, yeah, he's talking about a case, you know, that was, like he said, there was a lot of talk and stuff. 2 robberies and 2 murders, which, now, I do remember, well, I mean, I was young, I guess, whenever all this happened, but we did have a case where Tammy Acker was murdered here in Letcher County. So if any of y'all want to look that up, let's say Dr. Acker's daughter, Tammy Acker, and if I'm not badly mistaken, I think she was back home from college. It could have been UK, and I think some men came in and to rob them, and she was murdered in the process. But yeah, you guys, it happened, let's see, it happened years ago, but that was a big case here in Letcher County, and you guys can look that up if you're interested in it. was Tammy Acker. Okay, we'll go ahead and go back to this.
And I moved for a change of venue for the defendant, and it wasn't granted. And believe me, there was a lot of talk, and yet we tried to get a jury, and they did. They got a jury in that case, over my objection, but they did. They didn't grant the change of venue. And I would just ask the court maybe to look at that case, because when I asked for a change of venue, I was pretty much told that those things didn't matter much about reading about them, hearing about them, talking about them. And I think...
Okay, so that case that he was talking about, that there was rumors and things everywhere, and he had asked for, a change of venue for the defendant, and he didn't get it. So, he's bringing that up. So let's go ahead and listen to some more.
That's kind of the position they're in Letcher County. Now, I don't know why people are so concerned that maybe the Letcher County people couldn't be honest and fair, because they elected Mr. Stines. He put his trust in them, and they put their trust in him. And I think there's some position here where he should have the right to be tried in his own home county, where he feels comfortable and safe, and that he is around the people he knows. And again, I think from hearing from them, if it's that kind of a wide coverage, that was some kind of, there's so much to talk about. Where could you go? And where would you feel more comfortable? I know for his witnesses, at least they would be more convenient to be closer to home there, and it would be easier for them to come to court. Now, as far as these cases being high profile, I lived in Pulaski County. Several years ago, we had a sheriff that was assassinated. The trial of that person occurred right there in Pulaski County. And that was high coverage because he was assassinated. I just don't think that at this point in time, until we try to get a jury, and I think that's been the result of most of the cases that I've seen, that unless you try, you have to try, and then if you can't, then it's probably more pertinent to do it at that time. But at this juncture, I don't think that's been enough. Just having 3 people that are related either by blood or they were at one time. Mr. Butler was talking about that. But to have people that are working in the courthouse, one of them was a witness, and Mr. Hatton, I think he's the county attorney. I think that's kind of telling. And I also think that the people that testified at least have never had a situation where the Commonwealth asked for a change of venue. Now, I know this case may be unusual, but unusual isn't the case. And I would just ask the court to consider all of that and not change that at this time until we've at least tried to get a jury.
All right. Response, Mr.
Yes, Your Honor. Let me just say, Mr. Cox, I remember those cases. When I say this, I'm not.
Okay, let me stop it right there. I forgot about him, coming back and needing to say something, like, I guess a rebuttal, maybe. I don't know if I'm using the correct word. So we'll go ahead and go on.
Okay, but Mr. Bowles was in 1989, killing a gas station. Mr. Catching was in the early 90s. Mid-90s was when Mr. Catching. Just me and Mr. Cox both know that was before the fabulous internet and the coverage of which we see today from bloggers and YouTube, whatever. It is a much different reality.
Okay, so he's talking about the internet and said that it's before the famous internet, those cases that the defense had spoke about. And said that there was rumors and stuff. And yeah, the internet does make things more widespread. So, I'm hoping that they're thinking about that too. It's not just in Letcher County. It can be in other counties around us, in the state, in national, in different countries has heard about this case. So, he is, he's stating an important point that, it does go further. But, it doesn't mean that wherever the court decides to put this case, have it tried, doesn't mean that those people are going to have to, well, I guess what I'm saying is those people, if they've heard all these rumors too, where it's a widespread internet, that they're going to have to put their opinions aside too, not just the Letcher County people. It might, or I don't know if I should say, or may take a harder stance because it happened in our county, but wherever, what I'm saying though is wherever it's tried at, all the rumors that a person has heard, they're going to have to set them aside and listen to the facts. Well, go ahead. I'm sorry, y'all.
What we're dealing with exactly. I'd like to point out one of the things that's always struck me since we first got this case is that one of the admonishments that the judge gives a juror during the qualification is do not go by the scene of the crime and do your own investigation. This would require us to have a trial in the building of the crime. The video footage that we would show from the outside of the response to Mr. Stines leaving is of the building where they're going to walk in and out of every single day during this trial. So it's impractical, one, that they could not do that and not go by and look at the scene of the crime. The fact that these are both elected officials also cuts against their argument that it should be moved, Judge. Mr. Hatton, who's ran for county attorney many times, almost 16 years in, he said it's very team Stines or team Judge. It's just drawn a line in the community that we do not have a reasonable chance of getting a jury pool out of Letcher County. I believe when the numbers come back in Letcher County, their population is going to be less than 20,000 people because of the flood they had there a few years ago. I believe the number was, as Mr. Hatton said, in the mid-20s, but I believe the number is going to come back less than 20,000 in the next census. So, and they're losing population every day. I think he's said.
Okay, let me stop you here just a second. He was saying, that the jurors would have to go into the building where the crime had happened, the scene of the crime had happened. Yes, they would have to go into that building. That's where, the Letcher County Circuit Court is. It's upstairs, though, and there is side entrance that they can come up. So that's not necessarily they got to walk past, where it happened every day. They can take a different route, into the building. I do want to state that.
And very clearly, we had full 20,000 people just to possibly get 14% on the jury pool. This is from the county attorney who deals in these, and I can't imagine the phone calls the county attorney gets. The reason I don't want that job is the amount of phone calls they're going to have to get in a day just from citizens on a daily basis. The case of Brewster, 568 Southwest 2nd, 235, and Interpret Shepherd is requiring a change of venue when there's been prejudicial news coverage. It's undeniable. I think Marty's talked about the inaccuracy of some of these news reporting that are detrimental. These all the news occurred prior to trial, which that's why we're here today and not at trial. And the effect of such news coverage is reasonably likely to prevent a fair trial. And I believe every witness that we had affidavit signed said just couldn't get anybody that would sit and have to give a fair trial. So Cromwell thinks that the elements for the change of venue has been met, and we would request such.
All right. Any response?
The only thing is I'd say as far as prejudicial news coverage or any kind of coverage is based on like that video that you're talking about. And that's not the end of the story though. And I think I believe that with the trend has been, like what I've seen, in change of venue, You have to try. If in Pulaski County.
I don't think there's any case law that requires that.
It doesn't, but I can say this because of the trend of what they're saying, how much coverage it gets and talk and things like that. They sure got one in Pulaski. And that was an assassination of a sheriff.
And what year was that?
That was probably, and he may be right midnights, I can't remember exactly.
I think it was
Well, I think
94.
I agree, it was pre-internet.
94.
But the internet itself is such a big unknown, how many people are on it and where they're at and this, that, and the other. I mean, we could just go on and on, but where else?
Okay, so that's what I was saying, you know. Everybody, not just Letcher County, anyone who has heard about this case and who has heard the rumors, and I'm not against, you know, the Commonwealth or anything. I'm not against the defense. You know, I'm just saying that, you know, the Commonwealth brought up the fact that we now have the internet. And people are going to make, well, not people's going to make. People has heard all these rumors, and they have heard the online, you know, YouTubers stating their opinion and how they see it and stuff. So, you know, and it's not just people in Letcher County. I think, and this is just my opinion, I think a lot of Letcher County people don't even listen to the YouTubers, you know, on this case anymore. You know, they try to listen to the news and stuff. I mean, there may still be some that do, but it's everywhere. You know, wherever, you know, this coverage has went, is what I'm saying. They're going to have to put those, you know, feelings aside and put those rumors that they've heard aside to be fair and impartial. And that's what I'm trying to say. And that's my whole issue, you know, with it, is that it's not just here in our county. It may be a little tougher in our county. And I'm willing to admit that it may be a little tougher because, you know, there may still be people, you know, that may still stand on a strong opinion and that can't get past it. And then there may still be people that heard the rumors and can't get past it. But there's other places, people who's heard all this coverage, that's heard the rumors, who may not be able to get past it. So wherever it's going to be, wherever, you know, and I just want to see both of them get a fair trial. Wherever it's going to be, they're going to have to put those feelings and rumors aside to be fair and impartial. Okay, I think now, I don't know how I missed this. I mean, I heard it all. I guess I just forgot about these last statements. I think the judge might be able to is going to give his rulings now, or what he decides now.
Else in the world are we going to go? So that's what I would
Well, that'll be, if I do grant the petition, that'll be the court's decision. First of all, there's been a lot of questioning. I don't think anybody's trying to question the honesty or fairness of the people of Letcher County.
Well, thank you.
This is a unique situation, to say the least.
I do want to say thank you to the judge, you know, and I hope he feels that way, that nobody's, and that he and, you know, the Commonwealth or the defense is not trying to question the fairness and honestness of the Letcher County people. You know, I love my county and I love the people here.
At the request of defense counsel, I'm going to review the case law that they brought up today and cited. But I can tell you the court is going to be hard pressed not to grant this petition for change of venue. I cannot fathom the thought of reasonably being able to obtain a jury in Letcher County with the amount of coverage. I do believe the county attorney said, and I'd already kind of thought of that analogy, it seems very clear that you've got a very divisive situation where you have Team Stines and Team Mullins, and these are some irretractable positions that would make picking a jury in Letcher County all but impossible. But I'm going to withhold ruling.
Okay, let me stop here. Sounds like this possibly, it's ultimately up to the court, but it sounds like it's possibly not going to go the defense's way because he says he's not seeing how it can happen. And I disagree with that. You know, like I said, it's all over. But, you know, it's ultimately up to the court. But the rumors has been all over. And I do feel like the people of Letcher County, you know, they can be fair and impartial. I'm standing on that. They can be fair and impartial. There's some that might not, you know, that would still have their opinions and standing strong on it. But I believe they would admit to that. They would be truthful and honest when questioned to be a juror.
I'll issue a written ruling after reviewing the case law cited by the defense as well as the Commonwealth and get that ruling issued. Anything else we need to address today?
Yes, Your Honor.
Okay.
Your Honor, as to the second phase of that equation, Your Honor, of course, we would maintain our objection to their motion. But in the event the court grants the motion, Your Honor, then I believe the parties should have an opportunity to address. I think the statute talks about the preference being adjoining counties, first within the circuit, and then, Your Honor, so I understand it's the court's decision, obviously, but I do believe that the statute would require that we do have input as to the locale and be able to present evidence to the proposed location.
Well, and if I do grant the petition for change of venue, we can, I'll allow filings and requests and anything y'all wish to be heard on a potential location.
Yes, Your Honor,
I don't think, but like I said, it's not going to head to an adjacent county. I mean, realistically, if the court does grant the petition, I think we're going to need to be far away enough where the direct media coverage is not as focused as it's been in this part of the state. So,
Your Honor, as to that second equation, I mean, I understand, Your Honor, but I believe the analysis is a county to which there is no objection, Your Honor, on the second part of the analysis.
right, but it also requires it to be in the most convenient county in which a fair trial can be had. In my review, I've participated in change of venue cases, and in my review of the law that's been promulgated by the Supreme Court, there is wide discretion vested within the circuit court on picking that final destination. So
Yes, Your Honor.
we'll address that at the appropriate time. All right, anything else today?
Looking for the call, Your Honor.
Mr. Bartley, anything else on behalf of Mr. Stines?
No, Your Honor.
All right, the court will issue written findings and rulings in regards to all the matters that were heard today. I am going to contact the parties by email to start looking at some scheduling timelines about and getting this matter set for trial. I'll follow up with that, and then once the rulings are issued, we'll get a date set for any other additional outstanding matters. If there's nothing else to be heard, court will be in recess until the court rules for the proceedings.
Okay. Well, like I said, it's not sounding too good for the defense on the venue. But he did make a statement that it would be, if I understood it right, that it would not be in an adjacent county. It would have to be far enough. So the witnesses will have to travel. But he has not made that ruling yet. And that he said he had participated in changes of venue before. But what I've watched there, it seems like that he will probably change the venue. I don't agree, but it's up to the court. My opinion doesn't matter really in that. I think, like I said, that's where, I get, I want to stand up for the people of my county. And there may be some that are stuck in their ways, and will not change their mind. But like I said, I think they would be honest enough to say it, when called for a jury. And called in to be interviewed, to be on jury. I believe they would actually say it, if they had that strong of a stance, they would say it. But no matter where they put it, the people will have to put those rumors aside and, be fair and impartial. So, okay, this is my thoughts. Now, this is where I want to hear from you all. Letcher County has been through a lot. This tragedy affected the entire community. But does that automatically mean the citizens of Letcher County cannot be fair and impartial jurors? Let me know in your comments. Many people believe moving the case suggests local residents are incapable of setting aside personal feelings and following the evidence presented in court. Others argue that because this case involves a former sheriff, a sitting judge, and extraordinary publicity, moving the trial is necessary to ensure a fair process for everyone involved. Ultimately, the court, not public opinion, not my opinion, will decide whether the venue should change. Okay? This is my question. Can a fair jury be seated in Letcher County? Should the trial stay where the crime occurred? Or is moving the trial the best way to ensure justice? As always, remember that Sean Mickey Stines is presumed innocent unless and until proven guilty in court. We'll continue following every development in this case and bring you updates as they happen. If you're new here, please like, subscribe, and share. This is Nova Rain, and I'll see you in the next one.